The court order setting the hearing for today required Mr. Salas to appear in person.
Ms. Flores, I suspect that to be the case, but I don't recall specifically. Would you tell the court if that is true or not true?
I'm looking into the notes, Your Honor.
Do you know the answer, Mr. Chu?
Judge, I don't. I mean, I know this is a hybrid court that you operate unless you unless you tell the parties to come in person. I mean, that's been my
Ms. Garcia has
policy.
the impression that that is in fact the case for this hearing.
Refer you to the TRO and the order setting hearing on page 2. All participants, including respondent Hugo Salas, are ordered to appear on the date and time set for the hearing physically in the courtroom.
Give
of
the
this
court
court.
the file stamp date. December the 5th. I'm pulling up the file. And I'll take judicial notice. I mean, I'll figure out what the order says momentarily. But Mr. Chu, were you and Mr. Salas present in person in court earlier today?
Yes, Judge, we were present this morning in person. We were ready at 10 a.m. Ms. Linnes had an objection to the visiting judge, so we had to reschedule everything to come back at 2.
And you're referencing page 2, Ms. Garcia?
Yes, sir.
All participants, including respondent Hugo Salas, are ordered to appear on the date and time set for the hearing physically in court. So, I mean, you're court ordered to be here. So, I guess 2 questions. First question, Ms. Garcia, have you had an opportunity to meaningfully confer with Mr. Chu?
I conferred with Mr. Chu on November 7th, Judge, and I uploaded those email communications for the court's consideration.
So the answer is no.
The answer is yes, Judge.
Have you had an opportunity to meaningfully confer today?
No.
All right. Mr. Chu, anything preventing you and your client from coming right now?
Judge, for myself, yes, I have other stuff that I need to do at the court here, so I just need to be on standby. But I can ask my client to go in person, Judge.
Participants. It doesn't say parties or counsel, just participants. Any objection to carving that exception?
Yes, Judge. I guess if you're talking about witnesses and
I'm
whatnot.
asking Ms. Garcia in response to your request.
I don't mind if Mr. Chu is not in the courtroom, Judge, but Mr. Salas, the whole purpose, the basis of this entire request is.
Well, I remember the previous orders, and ostensibly those have expired by operation of the final orders in this case. Mr. Salas, does anything prevent you from coming to court right now?
No, nothing prevents me from going to court right now.
All right, then we have about an hour before we begin our next docket. So, Mr. Salas, make your way to court. Ostensibly, no matter where you're at in Webb County, it's going to take you at least 12 minutes. That should give Ms. Garcia and Mr. Chu some time to talk. And actually, I'm going to allow you to log off right now to start making your way because I have questions for both lawyers. So you can log off. I'll mark you as present by video conference, and we'll see you in court momentarily.
Thank you.
Before you confer with Mr. Chu, what is it your client is requesting and how does she intend to prove that?
Your Honor, in the courtroom, I have Officer Escobar, who responded to the call, made the subject of this request for modification. He's prepared to testify, and I do have the body cam video to support his testimony, Judge, and also for the court to view exactly what happened that day when Mr. Hugo allegedly was drunk driving.
So by way of evidence through testimony in that body cam, you're going to request?
We're going to request that possession of the minor children be restricted, Judge, that it be supervised, and also that Mr. Salas be required to submit to breathalyzers because his alcoholism, my client believes, is worse than ever suspected. So we would like breathalyzer as well, Judge. We would like an injunction preventing him from drinking 12 hours before any visits with the children and during his visits. We do not want him, we want an injunction to prohibit him from driving with the girls at all, Judge. And we do want him to complete alcohol treatment, but most importantly, for the best interest of the children, it is best that they not have visits with him unsupervised because we believe his alcoholism is out of control. He's in denial about it and refuses to do anything about it, Judge.
I was gonna ask Mr. Chu a question, but I guess now you've prompted the court in other directions. Remind the court the reason, I don't remember. So the reason the court initially during the underlying case had an in-person mandate or order in this case was because of the tests that were ordered previously.
I'm sorry, can you repeat the question, Judge?
Ostensibly, the court had in-person orders prior to the final order. In this case, in the underlying case, but ostensibly that was done because of positive tests.
That was done because of his refusal to test.
Was there ever a positive test?
The divorce decree required him to provide results from an alleged hair follicle test, and he's not provided that to us at all, in violation of the court.
Those things never
Okay,
happened, and then the
divorce.
parties reached an agreement.
I'm sorry, an agreement?
I don't remember making a decision. I think the
No.
parties reached an agreement regarding the full outcome.
Yes.
Right.
We went to mediation with Ms.
Right.
Cigarroa in August. We had another hearing here with regard to attorney's fees.
So there was no positive test, but if there is a refusal or invalidity test, it's a legal positive, not an actual
Correct.
positive. I recall. And any dispute with those facts on the record, Mr. Chu?
We dispute everything, Judge. The affidavit is blatant with hearsay and speculation. The officer is going to testify that Mr. Salas was given a ticket. He was not arrested. Based on that hearsay affidavit, my client has not had access to his children since December 5th, Judge. He's neither been able to see them. He's neither been able to talk to them for about 12 days now, Your Honor. So we're ready to proceed.
Well, and I guess that answers my next question. So you are aware, at least in writing, but you are aware of the request being made by Ms. Salas, and I guess you're going to dispute all of that.
Yes, Judge, we're disputing all that. I mean, she's already prevented him from seeing his children based on the ex parte, order that was signed. So he hasn't been able to see or talk to his children since December 5th.
And I guess the next question I was going to ask the staff, but I guess you've now answered that question, Mr. Chu. This isn't a pre-filed case. It was just the result of the stop or whatever it was.
No, there was never an arrest, Judge. There's not a pre-file. There wasn't anything. There was no arrest. It was a citation for backing up into a car. So
But
all
the-
these speculation of drunk driving or intoxication, that's with moving, Your Honor. So
Okay, I just, so if it was a class A or class B, it's 50-50, it's. kinda
it's
whack.
a class C, Judge. Yeah, so
All right.
it's a citation class C only.
Well, I tell you what, Mr. Chu, Ms. Garcia, while Mr. Salas makes his way downtown, at least talk. I mean, if you can look, I've counted 1, 2, 3, 4, 5 requests. If you can will it down to 4, you're in a much better position, at least. And I don't care if you agree one way or the other, or disagree one way or the other, but I mean, so at least talk. And that'll make the best use of your time while we wait for Mr. Salas. Anything else before we break, Ms. Garcia?
No, Judge, just to respond, the officer is going to clarify all the reasons why he was unable to make an arrest that time. So the lack of an arrest is not indicative of bad behavior, troubling behavior.
Well, I mean, I guess I can't just, as a matter of law, it's what's the word? There's two sides to that coin, right? So the court can't make any inference if there is or isn't an arrest. It's just a set of facts.
Correct.
Because even if there had been an arrest, this court is not exercising its criminal jurisdiction, and I'm not
Exactly.
going to find whether he is or is not guilty of any offense here. It's just what the conduct, if any, is indicative of.
I think that's correct, Judge. It's either, it's either they're pregnant or they're not pregnant, and the fact is there a danger to the children, and the children was not with him at that time, Judge. So
Well, not necessarily, no. So that's a little different, and I want to parse parse words, right? So what I'm saying is the court at this exercising its family law jurisdiction isn't going to determine whether Mr. Salas is guilty or not guilty of drunk driving. But to use your analogy, we're not here to determine whether somebody is pregnant or not. The court is here to determine whether there's any sexual activity. That's different. See, so we're not looking at guilt or innocence. We're just looking at conduct as it may or may not affect the children. And I don't know what the evidence is going to show. But so talk to each other about all these things, and we'll wait for Mr. Salas to arrive. All right, stand
Thank
by.
you, Judge. All right.
Court is back in session. This is the family law docket at Webb County Court at Law 2 for Wednesday, December 17, 2025. The time is now 2:36. This is cause number 2025 FLA 100C3. Court marks Ms. Garcia present in person. Person to her right is her client, Marcela Salas. Present by video conference is Nathan Chu. His client is now present in person. Ms. Garcia, how many witnesses do you have? Names?
Officer Escobar, Marcela Salas, and Hugo Salas.
Mr. Chu, do you have any witnesses?
Yes, Judge. I believe I filed my witness list with the court. Let me check.
Who are those persons?
One moment, Judge. Let me-
About 20 minutes before a group of 30 or so youth success court participants arrive. So court sees that you have named Mauricio Renteria, Edna Fairbairn, Officer Andres Sanchez, Officer Erika Escamilla, Marcela Salas, and yourself.
Yes, Judge. That's correct.
I don't know if I'm going to limit you to like an hour total or whether I should just keep you here till 9.
If I may, Judge.
Give me a second. Questions, Ms. Garcia, none of these 3 witnesses are going to have overlapping testimony?
Most of those witnesses have nothing to do with the basis of my request for temporary orders, Judge.
Well, they're your witnesses. I'm asking about
Oh,
your
my-
witnesses,
Mine.
right?
Overlapping? No.
Yeah, okay. Same question to you, Mr. Chu. These witnesses ostensibly, they're all going to testify as to different things?
Yes, Judge. Different things.
All right, and ostensibly, counsel, your duties end at 5, wherever you're at.
It would end at 7 today, Judge, because I have night court beginning at 5. So I have until 5 today.
But no, what I was going to do, because of the court order, is just order that you be here, because I'm going to recess in about an hour, and then we'll start at 5 in person. Everybody here in person at 5, and we'll just go until you all are done. So just plan accordingly. All right, anybody invoking the rule?
I invoke
Yes,
the,
I
my
invoke
own-
the rule, Judge.
All right, Officer Escobar, if you're present, please step forward. Marcela Salas, Hugo Salas, step forward. Mauricio Renteria, Edna Fairbairn, Officer Sanchez, Officer Escamilla, and Mr. Chu, raise your right hands. Just let me get the folks present. We have both parties present. Officer, tell the court your name, please. Officer Escobar, court marks you present in person. Tell the court your name, please.
Mauricio Renteria.
Mr. Renteria, welcome to court. The court marks you present in person. Court marks. You're Mauricio Renteria?
I am.
How are you? Who is logged in for you online?
I did like 30 minutes ago.
And is that device still logged in?
I don't think so.
It is. And so, Mr. Chu, just direct. Well, Edna Fairbairn was logged in. She is no longer logged in. Edna Salas. Mauricio Renteria, Edna Salas. Is Edna Salas, whose witness is that?
That's my witness, Judge.
All right, just let your witnesses know that they should be here in person. I don't think we're gonna get to them before yeah, anytime soon, so they can just make them make their way downtown. All right, Officer Escobar, Ms. Salas, Mr. Salas, and Mr. Renteria, please raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I swear, Your Honor.
I swear you on.
Everybody has answered yes. You may lower your hands. Ms. Salas and Mr. Salas, you're the parties. You can remain here in court. You may have a seat at council table and you may have a seat next to your lawyer, Ms. Salas. Officer Escobar, let me ask Ms. Garcia, who is your first witness?
Officer Escobar, Judge.
All right, so stay where you're at. Mr. Renteria, I'm gonna ask that you wait patiently outside. When you get called to testify, the gentleman in the back, our sergeant at arms, will come and let you know that we're ready to hear your testimony. Between now and then, don't talk to anybody about this case. If somebody attempts to talk to you about this case, you should let court security know. They'll inform me and we'll take it from there. Don't cause yourself to be in the hearing presence of anybody. Maybe somebody's walking by talking about the case. Just remove yourself from that situation. Do you have any questions for me? Also, don't listen to this case in person or online. You understand this? You understand this? All right, you may wait outside. Thank you. Officer, you may have a seat here on the witness stand. Court staff is preparing that device.
Your Honor, I don't know who else is online. I would just like an admonishment that no one can watch these proceedings on YouTube.
I did.
And if there is any way that the court can monitor that to make sure.
You're gonna have to ask on examination.
Okay.
Give us a second while we set up that device. As that device gets set up, Officer Escobar, the lawyers are gonna ask you some questions. I'm gonna ask that you pause your answers, listen to the full question, wait for a second or two until you've heard the full answer, or full question. Then you can answer. If you hear one of the lawyers, Ms. Garcia or Mr. Chu, object, just pause and I'll let you know if you can answer. Do you have any questions? Just want to make sure, Ms. Flores, that microphone is on. Yes, what device are you? Gotcha. Just confirm that microphone is on. Negative. All right, Ms. Garcia, you may proceed when ready.
Thank you. Officer, can you please state your full name for the record?
Yes, Alejandro Escobar.
And can you let the court know how you were employed?
I am employed by the city of Laredo for the police department
How long have you been a police officer?
for approximately a year and 9 months.
Okay. And were you on duty on November 5th, 2025?
Yes, I was.
And just about, you're here because you were subpoenaed to be here, correct?
Correct.
I did ask for certain documents. Were you able to bring the documents?
I was able to bring notes.
Okay, thank you. On November 5th, 2025, did you respond to an accident at 7521 Country Club Drive?
Yes,
After reviewing your subpoena, did you review the file to refresh your memory as to the events of that day?
yes,
Are you sure that you're fully refreshed with regard to that?
on said day, yes.
Okay. And can you please describe the call you received to respond to 7521 Country Club Drive on November 5th, 2025?
Okay, so the call came in as a hit and run report. I respond, it's by Country Club. Upon arrival, I speak with a Army sergeant and she tells me that a vehicle.
Objection, hearsay, Judge.
Sustained.
Without telling me exactly what the Army sergeant said after, let me ask you some questions. Were you able to speak to that Army sergeant who made the call?
Briefly.
Okay. From the information you gathered from her, from your communications, can you summarize for the court what her complaint was?
Objection, still hearsay, Judge. That's, you learned about the hearsay statement after speaking with the person which is out of court, Judge.
Your Honor, this is a police investigation pursuant to, and actually there's a hearsay exception with regard to public reports, public information. This was the activity of a public police officer, Judge. So there's an exception to the hearsay rules with regard to that.
What is the exception?
803, public records and reports, 803-8. A record of a public office setting forth activities of the office, matters observed pursuant to a duty.
Right,
imposed-
pursuant to 803-8.
Yes.
A sub Roman numeral 2 or small I2, and I. It's respectfully overruled. You may answer.
Go ahead.
Could you repeat the question?
Yes, after speaking with the Army Sergeant, from your conversation and investigation as an official police officer, what is your understanding of the complaint that day?
So as per my complainant, she informed me of a silver Toyota Tundra backing up into her vehicle.
And what was her complaint as a result of that backing up into the vehicle?
Objection, hearsay, Judge.
It's an exception to hearsay. This is a formal investigation by a public officer.
Overruled. You
But-
may answer. You may answer.
Her complaint was that the Tundra hit her vehicle and left the scene.
Okay, what did you do next?
She showed me a picture of the license plates and she told me that it went into a gated community that was right next to her apartment complex. I proceeded to immediately go into the property to try to find the Tundra.
Before we go any further, what time of the day was this?
It was approximately 6 p.m. or so.
Okay, Your Honor, at this time, I do want to offer into evidence a business record affidavit that has been filed of record and has also been uploaded to case lines that was signed by the custodian of records for the Laredo Police Department. And that is in attachment number 3.
You mean, so this is case center
Center
document 3?
Yes.
Any objection to the court receiving that, Mr. Chu?
Yes, we object, Judge. Proper predicate has not been laid. This case line filing, which is filed this morning or this afternoon, Judge.
It's a
So
business.
we haven't had notice of it.
It was filed
So-
today, Judge. It's a business record affidavit signed yesterday by the custodian of records. It sets out the predicate for self-authentication under Rule 903 of the Texas Rules of Evidence, as well as the hearsay exception under Rule 803, Judge.
Judge, we still need time to challenge it. We have not had any ample time. She had just filed it this morning, Your Honor.
I mean, I should have asked before we began. You ostensibly you had enough time to confer on these matters,
Yes, Judge.
Mr. Chu?
Yes, Judge. And we object to all the filings because it was just filed today, this morning. So
It's a TRO, but ostensibly, if they were filed this morning, Mr. Chu, you did get the notice and you're able to open, review, receive, download, and all these things.
yes, Judge, but we still need time to be able to object to the business record, which we haven't had time to do that.
You were set at 9, 10 this
We were
morning?
set at 10. We were set at 10, Judge, and all this filing came after 10 o'clock.
Response?
Your Honor, I had checked with the court, not only Friday, but Monday to verify the court's, whether or not there was going to be a visiting judge. So I filed an objection. I anticipated that Your Honor would not have any availability until January 6th. So I did not upload anything to case lines and I did not file anything because of the anticipation that this case was not going to be heard until January, Judge.
Well, so let me ask this, Mr. Chu. So there's 2 different objections on the floor, on the table, and that's One, so respond to each, Ms. Garcia. One is, I think he's saying predicate, and the second is timeliness. Go ahead.
Your Honor, the business record affidavit has been filed. It is an affidavit. It speaks for itself. And if I need to get it admitted into any other way, then it's also pursuant to a public records request. And so with a public records request, it's also admissible under public records.
All right, any reply to that response? Anything else on with regard to that objection?
Yes, Judge, we still need it still needs to be on file at least 10 business days, Judge, and this is way inside of that 10 business days. It was just filed this morning, Judge.
Your Honor, they did not make an appearance until yesterday, Judge. Yesterday or the
But-
day before, so it would be impossible to give them notice for 10 days.
Regardless,
Then
Judge,
if that's the case, then I would ask the court to recess this matter so that we could have this heard within 10 days from the filing of this business record affidavit.
Well,
Judge,
so,
this motion was.
Ms. Garcia, Mr. Chu, this is exactly what I'm trying to avoid. And what I'm trying to avoid, Mr. Chu, and maybe I shouldn't because it's your objection, right? I should just say sustain and then there we go. And then the problem with sustaining the objection as I see it is that it, well, number one, delays, and you all know my judicial philosophy on that. One, two, but really, and I don't know what impact, if any, it has on the children, which is really the concern for the court.
So that's
But if I
my
were
third
your
objection would be
client,
relevance.
let
My
me-
third
let me-
objection
let
would
me
be
finish-
relevance,
finish
Judge.
My
Yeah.
thought, this is why you should be in person. So, but if I were Mr. Salas with the objection, if the court sustains it, then everything stays the same. Ostensibly over the holidays, that's not the position that anybody would want themselves in. You see what I'm saying? But I mean, I can sustain and then we'll come back. But the problem there is, I think, without receiving any evidence, everything stays the same until evidence and testimony can be fully heard.
I don't think that's
This
the,
is exactly why I wanted you all to confer.
Judge, we've conferred and we can't reach an agreement and it doesn't stay the same because they have the burden to prove there is a danger to the children, thereby keeping Mr. Salas away from the children. I mean, they've already done that, but this is their day in court. They filed this since December. I mean, Your Honor signed this since December 5th, Judge, well, more than the 10 days. And here they're trying to surprise everybody by filing this stuff at the last minute, trying to get the business records in without a proper custodian to prove it up.
Judge.
I mean,
did
they have
not-
the officer before you to testify what he observed, and he's there, he's here.
All
They
right,
did-
sustain, let's move on.
Officer, did you have occasion to turn your body camera on?
At the time of the incident, yes.
Okay, I would like to introduce into evidence number 5, Judge, which is the body camera, and I'm going to ask you to take a look at it,
You're asking for the video to be played.
to be played, so that my client can take a look at it, so that he can authenticate it.
Court staff will prompt and play number 5.
Judge, object to the evidence coming in, proper predicate hasn't been laid, Your Honor.
But
I'm-
I'm not admitting it at this time.
I'm trying to lay the predicate. It's
Let-
over an hour long, and I'm willing to sit here and have him look at the entirety of it so that he can verify it is his complete body cam video footage. So I'm willing to do that for over an hour so the officer can verify.
I'm certainly not willing to sit here for an hour.
And
Y'all.
either way, Judge, you have a live witness here to testify.
I think the images, Judge, will assist this court in making a determination in the best interest of the children.
So the video is playing. Any questions?
Mr. Officer Escobar, do you recognize this video?
Yes.
Do you see the time, the date and the time above?
Yes.
Is that a true and correct time in which you initiated your body cam recording at Mr. Salas's residence on November 5th, 20?
Yes.
Laredo Police, Policía Laredo.
Do you know how long you may have been there?
Approximately 30 to 40 minutes waiting for him to step outside.
Okay. And after that,
Victor 5.
I picked up his vehicle.
Okay, and after that,
After
For
that, I
the
returned
vehicle
back
on
to
my
my
57,
complainant.
what is the name of the registered
okay,
owner?
the Army Sergeant,
Yes,
and did you have occasion to go back to Mr. Salas's?
yes,
Does your body camera video show all of that?
yes.
Your Honor, just to make sure that he reviews it to verify that it contains all that. I'd like to go to.
Is that a request to continue playing or to stop?
Laredo Police, Policía Laredo.
Everything that he discussed.
Oh, I see. The request, Ms. Flores, is that you fast forward the video.
If we can fast forward to the tape at 7:57 minutes 55 seconds, or the time of 18:36. Little bit back. $7:55. You recognize that, officer?
Yes.
And what were you doing at that time?
Judge, objection, he's testifying to evidence not in,
Do you recognize, is that a natural continuation of your
Ms.
call?
Brown, this is Officer Escobar with
Yeah.
the Laredo Police
Okay.
Department. I'm here with the
Um,
truck. What did your command say regarding the?
Okay,
Charges.
can we move to time?
Okay, sounds
40
good. I'm
minutes.
here trying, just to let you know, I'm here trying to make contact with the
Came out about-
owner of the vehicle. I see the truck parked here on the drive. Mr. Salas, tengo que hablar con usted aquí afuera. ¿Puede salir para afuera? ¿Tiene armas?
No, ¿qué pasó?
No, pasa acá afuera conmigo.
¿Qué pasó?
Estuvo involucrado en un accidente y no se paró. Salga para afuera, si no lo voy a sacar. Salga para afuera. No, véngase para acá, por favor. Voy a usar más fuerzas. ¿No tienes armas? ¿Qué tienes aquí? Mr. Salas, ¿por qué no salías? Vamos para acá. So, mira, estuvo involucrado en un choque ahorita, Mr. Salas. No se paró.
¿Dónde estuvo?
Hmm?
Where?
Over here, on Country Club. Let's go over here.
So then you said that you went back to the complainant, correct?
Yes.
Estuvo involucrado en un accidente. y no se paró, nada más dio un número de teléfono,
Judge,
dijo,
again,
I got it, I'll fix
testifying
it.
from
¿Por qué no se
a
paró? Está
video that's
tomado.
not admitted
I'm
into
checking
evidence,
my
Judge.
next, if we can now go to timestamp
Mr.
54.
Salas, mira,
Overruled, it's not being introduced.
Oh, I'm sorry, it's not 54. Yes, if we can go to 54, please.
I'm so sorry for the delay. I understand that you had a picture. May I see it?
Stop right
Which
there.
one?
I can ask
The
you a
one that you took of the male soldier.
Does that depict when you
So
went back
we'll-
to talk to the complainant?
Yes,
Is that the Army Sergeant complainant that you were talking about?
yes,
Okay. And then you said you went back to the residence, correct?
correct.
So if we can go back to (1 hour, 11 minutes).
How's the car? I called the Sobriety.
Laredo Police. Hello.
Stop
I
the
just
video
responded
there.
to Mr. Salas. Salas, I kept your wallet.
Officer, does that depict the next activity that you described going back to Mr. Salas's residence at 7521 Country Club Drive?
Yes,
The entire time of this video, if we can go to the end to mark the end time. Just want to note it. It's at 1 hour, 13 minutes, 15 seconds, more or less. And the time is 19:42. Is that a complete depiction of your response time to Hugo Salas's office after this call on November 5th, 2025, from beginning to end?
Yes,
Does this video accurately represent the video that you captured on your body camera on that night?
yes,
Did you upload it to your regular system for preservation?
yes,
Is that standard practice with regard to the Laredo Police Department?
yes,
Is this a true and correct copy of the body camera image that your body camera took in responding to this call on November 5th, 2025 in its entirety?
yes, it is.
I'd like to offer this into evidence, Judge.
Response, if any?
Just one additional question. Officer, were there any deletions or additions to this video?
No,
No objection, Judge.
Thank you.
So, Ms. Flores, what case center number is that?
5, Your Honor.
Case center 5 is hereby admitted without objection as movements 1.
Thank you.
Ms. Garcia.
Officer, you said that do you recall the Army Sergeant's name?
yes, I do.
What is her name?
Sergeant Anaya Brown.
Is she from Laredo?
No, she's not.
Do you have any reason to believe that she continues to stay in Laredo today?
I do not know.
Okay. And just to refresh the court's memory, you stated that she provided you a photograph.
She did show me a photo.
What photo was that, if you can describe it?
She showed me a photo of Mr. Salas inside his Tundra.
Okay. How were you able to deduce Mr. Salas being the person involved in that accident driving the Toyota Tundra?
Could you rephrase that?
How were you able to confirm rather, that Hugo Salas was the person driving the Toyota Tundra in this accident on November 5th, 2025?
I confirmed this based off her statement.
Excuse me?
I confirmed this based off her statement and the photo she showed me.
Okay. So how were you able to get his address?
Once she provided me the license plates, I ran them through our mobile computer terminal and found an address of Plymouth, but she told me he had gone into that property.
Okay. How did you get his apartment number or condo number?
I saw the Tundra parked outside.
Okay. So what did you do next?
I proceeded to check the Tundra to see if the driver was possibly in there.
And what did you find?
An empty truck.
What did you do next?
I proceeded to knock at the residence.
Okay, you testified previously that he did not come to the door for 40 minutes. Is that correct?
Approximately, yes.
Okay. Did you attempt to call him on the telephone?
I believe I did ask the dispatch, yes, to try to
Okay.
find the phone.
How did you have his phone number?
We have it through our database.
Okay. Did you call his number?
I can't recall.
Do you want me to
Exactly.
refresh your memory?
Yes, please.
If we can play exhibit number 1, tape time is at 7 minutes, 55 seconds, please.
Is this the same video?
Yes.
Ms. Flores, go ahead.
Ms. Brown, this is Officer Escobar with the Laredo Police Department. I'm here with the truck. What did your command say regarding the charges?
That you calling his cell phone?
No, I was calling the sergeant.
Okay, can you go back to 1836 and 755? Do I have that wrong? Okay, I'm gonna move on. I have. I'm gonna move on. I'm sorry, Judge. I have that wrong.
Go ahead.
What did you do after that?
After the phone call,
Yes.
I proceeded to ask the sergeant to see if she wanted to press charges for hit and run.
And what was her response?
She wanted to confirm with her major to see if she could proceed with charges.
Okay, did you call a tow truck?
Yes, I did.
You testified that Mr. Salas eventually came out, correct?
Yes,
Was the tow truck already there?
it was already there. Yes.
Was there noise? Were there lights?
My lights were on and the tow truck's lights were on.
Okay. Can we go to tape time 39 minutes, 30 seconds, please?
And Judge, I object again to relevance. This is temporary orders, Judge. We're here as if we were on the merits of the case, Your Honor. So, I mean, I haven't heard anything about the children or any danger to the children, or if the children were involved.
Your judge, this is a hit and run accident. The officer already testified that the complainant said she was hit, that the driver who has been identified as Hugo Salas left the scene. I need to develop the testimony because I think any parent would agree with me that a person, and we're getting to the meat of it, that Mr. Salas is intoxicated.
Go ahead, Ms. Flores.
Ya le noté todos los daños. Tenía daños acá. Adelante nada más el bumper. Bumper y la headlight. Era lo único. Ya la intenté chingos de veces. Déjame intentarlo otra vez. Mr. Salas. Laredo Police Department. Mr. Salas. Mr. Salas, tengo que hablar con usted aquí afuera. ¿Puede salir para afuera? ¿Tiene armas?
No, ¿qué pasó?
No, pasa acá afuera conmigo.
¿Qué pasó?
Estuve involucrado en un accidente y no se paró. Salga para afuera, si no lo voy a sacar. Salga para afuera. No, véngase para acá, por favor. Voy a usar más fuerzas. ¿No tienes armas? ¿Qué tienes aquí? Mr. Salas, ¿por qué no salías? Vamos por acá. So, mira, estuve involucrado en un choque ahorita, Mr. Salas. No se paró.
I don't know.
Hmm?
Where?
Over here, on Country Club. Let's go over here. Estuvo involucrado en un accidente y no se paró. Nada más dio un número de teléfono. Dijo, I got it, I'll fix it. ¿Por qué no se paró? Está tomado.
Digo, no, digo, nomás. Confexen, ya.
Mr. Salas, mira, they're gonna take it. It's gonna get impounded.
Okay.
Were you driving?
Digo, antes era confexing.
Were you driving? Yes or no?
Back then, yes, I was driving.
Were you driving the truck right now?
No, ahorita no. I'm here at my house.
Okay, you didn't drive it right now when it was crashed? Who was driving it?
No.
The lady has
Digo, that's
the lady has a picture
Okay.
of you driving.
Fair enough.
Were you driving? Yes or no? She has a picture of you.
Okay. Can I call my lawyer, Nathan Thomas?
You have that, right?
Nathan Chu.
I'll let you use my phone number, all right? Do you have the keys?
Sí, claro. O sea,
Can I borrow them? It's gonna get impounded. Regardless of you calling your lawyer, it's gonna get impounded.
Can we
Okay,
stop the
okay,
tape right
I
there,
just-
Judge?
Because you're involved in a hit and run.
This, Florida's court staff will stop.
Just so I can ask the officer some questions. Does this refresh your memory as to what occurred?
Yes, it does.
Is Mr. Salas the person depicted in that video that we just saw? Mr. Salas sitting right here across from me at this table.
Yes, that's him.
When he first came out of the door, what did you notice? What smell did you notice?
A strong and distinct odor of alcoholic beverage.
When you saw Mr. Salas, what did you notice about his affect and his physical appearance?
He was disoriented.
Did it concern you that he may be intoxicated?
Objection, Judge, speculation.
This is his job, Judge.
All right, so
Judge.
here's the instruction in the ruling. Don't guess, don't speculate. You're here in your capacity as a Laredo police officer with 1 year and 9 months experience. In that capacity, you may respond. You can give your opinion. The objection is respectfully overruled. You may answer.
I did suspect him of being intoxicated.
And is that based on your training, knowledge, and experience as a Laredo police officer?
Yes, it is.
As your interview with him continued, and it goes on for about 10 more minutes, did you continue to see any behaviors that concerned you that he may be an intoxicated person?
Objection, speculation.
Based on your training, knowledge, experience, and interaction with Mr. Salas on that night?
Overruled. You may answer.
Yes, he did show signs.
Okay. Did Miss Brown at any time tell you or express to you her belief that he was intoxicated at the time of the accident?
Objection, speculation, and hearsay.
Sustained.
Based on your investigation as an officer, did you communicate with the complainant with regard to what she saw and experienced at the time of the accident?
Objection, hearsay, and speculation. This is
Overruled.
opinion from a third party, Judge.
Overruled. You may answer. The way it was asked, you may answer.
Yes, she told me that he appeared intoxicated.
Okay. Did she tell you that he smelled of alcohol?
Objection, hearsay.
Sustained.
From your
answer.
investigation and as an officer investigating this incident at the time of the accident on November 2nd, 2025, did the complainant express any concerns at the time of the accident that she smelled alcohol on the person who hit her?
Objection leading, objection hearsay, objection speculation.
Sustained as to leading.
From your investigation with Miss Brown, did she express any other concerns to you regarding the basis of this accident?
Objection, hearsay, Judge.
Overruled. You may answer.
Yes, she did. She had a concern that he might do this to other people.
Okay. Did she have any other concerns expressed to you during your investigation on the night of November 5th, 2025, as to whether or not this could be alcohol related?
Objection leading, objection hearsay.
Sustained as to leading.
Did Miss Brown, throughout your investigation, express any other concerns with regard to the condition of the driver alleged in this accident?
Objection hearsay.
Overruled. You may answer.
Yes, she did.
What did she express?
Objection hearsay.
Response.
This is the derivation of an investigation, Judge. I'm following up with his yes answer.
Judge, this is directly backdooring a hearsay and trying to get the hearsay statements in. She's not in court
I-
for me
Okay.
to.
I understand, overruled. You may answer.
She was concerned that he was intoxicated and would possibly do this again.
Okay. From your 14-minute conversation initially with Mr. Salas, did he admit he was driving?
No, he didn't.
Did he admit he was involved in a hit and run?
No,
You did tell him your opinion, though, that you felt he was intoxicated, correct?
yes,
During your investigation, isn't it true that told you that he offered to pay the driver?
Objection leading,
I believe it was in the video, Judge.
but I mean, the evidence speaks for itself, Your Honor.
Sustained.
Okay. You reviewed the video, correct?
yes,
Right
I
now.
did.
It was in Spanish, correct?
Yes,
Some of it was in English.
yes,
Do you recall Mr. Salas making any statement on that video with regard to his offer to pay the driver?
yes.
In your experience as an officer, do you have an opinion as to whether or not that could be an admission of guilt?
Objection, speculation, Judge.
Sustained. Don't answer.
Now-
Don't answer.
I would like the court to review the remainder of the video, Judge, so that, as Mr. Chu said, the video speaks for itself. For your honor to,
Any other questions?
yes, I do have other questions.
Go ahead.
Did Mr. Salas ever, you saw the video where he said he wanted to speak to his attorney, correct?
Correct.
Did he ever refer to his attorney in any other official capacity?
No,
I'm going to refresh your memory and take you to, if we can go to the tape at 43:15. 43 minutes, 15 seconds to refresh your memory.
That's all we need. Let's go outside, Mr. Salas.
Pero declarar a mí,
Háblale a tu lawyer, but let's do it outside, please.
yeah, but the judge. You know.
Call whoever you need, but let's do it outside, please.
Can we stop it there?
Well, you know what?
Did you hear what he said?
yes, I did.
What did he say?
He referenced his lawyer as a judge.
Okay. In that moment, I want your opinion as a person who was the recipient of that statement. In your opinion, why did he refer to his attorney as the judge?
Objection, speculation, Judge.
This is his opinion. He's the one that was the recipient. Mr. Salas specifically referred to Nathan Chu as my attorney, the
I know.
judge, to an official officer. So I want to know how the officer
so
took
let
that.
me ask this. I mean, we heard the video and the court will take notice of everyone's position, work capacity, but Ms. Garcia, in this case, taking all of this into account, what issue does that help the court resolve, or how does that play into the court's contemplation of the ultimate issues?
I'm going to get into Mr. Salas's driving history and past stops, Judge.
Well, I mean,
And also
you can
statements-
do that,
and
but
also-
Mr. Chu, but give me one
Yes.
second, but Mr. Chu's occupation has nothing to do with Mr. Salas's driving history.
Judge, the purpose of this is not to emphasize Mr. Chu's occupation. It is to emphasize Mr. Salas's name dropping of his attorney as a judge and his inability to take into consideration and admit that he has a drinking problem and instead gets away with these stops.
Objection, sidebar, Judge.
By possibly,
I mean,
Your Honor,
Let's
by possibly using.
so look, can find, driving history and all these things may or may not be relevant to this, but let's just move on at this point.
Speaking of his driving history, was it part of your stop on that night in investigation to look into Mr. Salas's driving history?
Yes, it was.
Do you recall what you saw with regard to his driving history that night?
Yes, I do. I recall.
Okay. Can you provide the court information with regard to his driving history that was part of your investigation on November 5th, 2025?
So regarding his history, I did notice that there was past instances of intoxicated person.
Okay. For other stops in the past?
After further review, it wasn't a stop. It was an intoxicated person at a business.
Okay. What date was that?
That was on October the 1st,
Of what year?
2025.
Okay. And from your review of his history, what did that incident include?
So the incident stated that there was a drunk person at the business Deutsch and Deutsch, and they requested him to be removed from the business.
Okay. Was he arrested?
He was not arrested.
What was the conclusion of that stop or that history?
On that stop, he had a friend named Erica pick him up.
Okay. But he was not arrested.
He was not arrested, no.
Okay. I do want to go to the tape again. Did you go back to speak with Miss Brown?
Yes, after I spoke with Mr. Salas, I did speak with Miss Brown.
Okay. Did she? If we can go to the tape, please. At the time, 57 minutes, 15 seconds.
Damage on your vehicle. Okay. So the front bumper. So I'm gonna use your license as your vehicle and my notepad as his vehicle. How did the accident happen?
This is my vehicle.
Mm-hmm.
So I was coming around the curve,
Okay.
and I
Coming southbound, right?
yes.
Okay.
Okay. And I noticed that the truck was backing up, and I'm putting on. I'm driving slow enough. So I'm like, okay, see this truck backing up. Let me, put my car in reverse.
Okay. Or maybe with your phone, do you think that's his truck? That's you.
This is me. This is him.
He's going north.
He was going this way, but at some point, I don't know when he started backing up.
He was in front of you.
He was in front of me, and he was backing up, and this is me coming, and I stop, and I'm trying to put my car in reverse, and I'm blowing, like I have my hand on the steering wheel, and I'm blowing with my arm because I'm using this hand to shift the gear. Mm-hmm. And as I'm blowing, I'm like trying to let him know, like I'm trying to back up, and he just keeps coming, and he just backs into me.
So I kind of want to say that maybe he missed that entrance, and then he was backing up to get that entrance?
Right.
Okay.
Yes.
Okay. Which part of his bumper did he hit you with?
The driver. No, it was with the passenger side.
With the passenger side. Okay.
Yes.
I did see damage on the passenger side bumper.
Yes. Because I was coming. So if this is me, this is him. I'm coming, of course, on my side of the road.
So he's kind of like doing like this.
Yeah. So he's backing up, and he's getting ready to go that way. So then he hits the front of my vehicle.
And he just said, "I'll pay for it. I'll pay for it." Something along those
lines. He did not stop. Like I put my vehicle in park. He proceeded to turn into the gate. I got out the car. I looked at my car. At first, I walked up. I was like halfway to him. I was like, "Hey, you hit my car." Then I go back and I look. I said, "You know, like you just hit my vehicle." His window is up, and he's not responding. So I walk closer, and I'm on the phone with my friend. I'm like, "Hey, you just hit my car," and he's like, "Are you good?" And he never gets out of the car. I was like, "No, like I have to, report this."
Okay.
He continues. I'll take care of it. Don't worry. His words are slurring. His eyes are low. He's like back and forth looking. He's playing in his phone.
As
Not
it
once
is,
did he get out.
as it is, he was very off right now. I could clearly say he was intoxicated
Yes.
without even doing the SFSTs.
See? And at first, when I was speaking to him, I was like, maybe he doesn't speak English,
No, he did.
because he kept saying, "Oh, don't worry, I'll take care of it. I'll fix your car. I'll fix it." And he was just kept mumbling, and then he started giving me his phone number, and I said, "Son, I gotta get your information." And he just started giving me his phone number. So I was just like,
May I borrow the insurance info for your vehicle?
I don't think we.
That's enough for that.
Again, this is a rental.
I'm sorry.
Go ahead. Any questions?
Did Miss Brown press charges?
No, she did not.
Based on your investigation and your communications and interactions with her, what was the reason for her not pressing charges at that time?
Jackson speculation.
Overruled. You can answer if you know. Don't guess, don't speculate, but if you know, you can answer.
Yes, so Ms. Brown advised me that the reason she didn't want to press charges was because she was deployed here in Laredo, and she asked me if she would have to go to court if she would press charges, and I told her that there would be a possibility of her going to court, so that since I told her that, she didn't want to press charges.
All right, now's a good juncture to pause. The court is going to now take up and consider the Youth Success Court docket. We have a number of young persons and their parents that are here. They've been waiting patiently. So I'm not releasing anyone. Certainly, you can get off the stand and use the facilities, but don't talk to anybody about this case until we commence. Again, I suspect, without knowing anything else, that I'll be able to talk to and make decisions on each of the Youth Success Court participants within an hour, maybe 60 to 65, 70 minutes, best guess. So I'm going to order Mr. Chu and Ms. Garcia, just based on thus far, right? And the court probably hasn't heard but a fraction of the possible evidence and testimony, but talk to each other between now and then and see if there's any room for agreements. If there isn't full agreement, we'll continue this in about an hour. Any questions, Ms. Garcia?
No, Judge.
Any questions, Ms. Salas? Court has heard no. Any questions, Mr. Salas? Mr. Chu, any questions?
No, Judge.
Officer Escobar, do you have any questions?
No.
Okay, you may step down and our Sergeant at Arms will let you know when we'll continue next. All right, you may step down momentarily.
Yes, sir.
Last we left off, Ms. Salas was examining Officer Escobar through her lawyer, Ms. Garcia. Court notes Ms. Garcia present in person. Her client, Ms. Salas, is on her right. Mr. Chu is present in person. His client is on his left. Mr. Salas, Officer Escobar is present. Ms. Garcia, are you ready to proceed?
Yes, Your Honor.
Officer Escobar, please make your way forward. Please have a seat here on the witness stand. All of the same instructions as before apply. Ms. Garcia, you may proceed when ready.
Thank you. Just to summarize, you had stated that after you spoke with Ms. Brown the second time, you went back for a second time to Mr. Salas's residence, correct?
Yes, I did.
Can we run the videotape?
I just need to make sure, Ms. Flores, that the microphone is on.
Objection, Judge, that's an answered. We already asked that question and already shown that video.
I'm sorry, what was the question?
If he had gone back to Mr. Salas's house the second time.
Sustained.
Okay. Can we go back to that video though?
Objection again, Judge. That video's already been played.
Response?
I would just want to show that my client was there, Judge, but I can move on.
All right.
Do you recall talking to him and about his intoxication that second time that you went back?
Objection calls, it's a leading question and speculation.
Sustained and overruled. So you can move on and rephrase the leading portion of that question.
Okay. You do recall going back the second time, correct?
Yes, I do.
From your investigation and interaction with Mr. Salas, what was the point of going back the second time?
So the point of going back the second time was to give him his wallet and just to try to get one last confession, but I didn't get a confession of him admitting to driving.
Okay. Did you have a conversation with him about your suspicions of him being intoxicated while driving?
Objection, leading and legal conclusion.
Overruled. You may answer.
Yes, a brief one.
Okay. From your communications, interactions in an official investigation, can you summarize for the court what that conversation included?
Objection, that's an answer, Judge. And ask for a summary of testimony that he's already given.
Overruled. You may answer.
I told him that I suspected him of being intoxicated, that I just wanted him to admit that he was driving at the
Okay.
moment so I could proceed with an arrest.
Okay. Did you arrest him?
I did not know.
Can you explain to the court why you didn't?
I didn't arrest him for the hit and run because Ms. Brown did not want to press charges, and I didn't arrest him for driving while intoxicated because he did not admit to me to having operated the vehicle.
If Miss Brown were to change her mind, would he still be, could there be a potential for an arrest in the future?
Objection, speculation and leading.
Sustained. Don't answer.
If a complainant in a traffic accident wants to pursue charges at a later time from the date of the accident, is it possible to still continue pursuing charges
Objection.
in your experience as an investigator?
Objection calls for, it's a hypothetical.
And hypotheticals are allowed, Judge.
It's still leading also.
I mean, I guess hypotheticals are allowed. I just don't know that it helps. I mean, no matter what the response is, I don't know how it helps this court make a decision. I mean,
Well,
you can
Judge-
answer, but I mean, the overruled, you can answer.
Based off the complainant, if she wished, I could take out a warrant for hit and run.
Okay, thank you. I'll pass the witness, Judge.
That was direct examination. Anything on cross?
Yes,
Go ahead.
good evening, officer. My name is Nathan Henry Chu. I represent Mr. Hugo Salas. Now, you said you've been on the force for 1 year and 9 months?
Approximately, yes.
Okay. And have you done any DWI arrest?
Yes, sir.
Okay. Now, when you do a DWI arrest, do you first have your suspicions of intoxication?
Yes, sir, I do.
And then thereafter, what do?
I build probable cause.
Okay, which would include what?
It includes the standard field sobriety test or seeing a traffic infraction.
Okay. What is a standard field sobriety test?
It's a series of tests that we do, which include a horizontal gaze nystagmus, walk and turn test, and one leg stand test.
Okay. And that would give you clues as to intoxication. Would that be, is that right?
It would give me clues, yes.
Okay, and that would give you probable cause for driving while intoxicated, is that right?
It helps build the case, yes.
Okay, you don't just jump to the conclusion of intoxication,
I do not know.
but that's what you did here.
Objection, Judge?
This cross-examination, Judge.
Overruled. You can answer.
I build up to it. I only arrest if I have my probable cause. I had reasonable suspicion, but I was not able to build my probable cause with Mr. Salas.
Okay. Now, officer, is consuming alcohol illegal?
No, it's not.
And you can be intoxicated without driving.
That is correct.
And intoxication without operating a motor vehicle, is that illegal?
No, sir, it's not.
How did you end up with Mr. Hugo's wallet?
I frisked him. I patted him down.
Okay. When he was outside?
Yes, sir.
Your Honor, I'm going to object to relevance. I don't know what purpose the officer's
I don't know.
confiscation
Relevance?
of a wallet has to
Relevant?
do with the
I
allegations
don't know.
against Mr.
The objection
Salas.
is relevance. What's the response, if any?
Judge, I am just cross-examining the officer. Counsel spent over an hour with the officer going over the same thing, Judge.
I'll give
didn't
you,
talk about the wallet.
I'll give you some leeway. You may pursue a little bit and then just move on. Go ahead. You can answer.
Now, officer, at what point in time was Mr. Salas detained?
He was not detained.
During the whole time that you spoke to Mr. Salas, he was not detained.
No, sir, he was not.
Okay. Did you read him his Miranda rights?
At some point, yes, I did.
Okay. And but yet you continue to talk to him.
He didn't answer any questions.
And did you inform Mr. Salas at some point that you were not going to arrest him
I did.
and that you were just going to tow his vehicle for the investigation for the accident?
That is correct.
Subsequently, the vehicle was released to Mr. Salas.
Is there a question?
Was the vehicle later released to Mr. Salas?
Yes, it was.
Okay. Officer, on the early evening or dusk of November 5th, did Mr. Salas have his children?
Objection, relevance.
This is completely relevant because it deals with the children. This is why we're here been here the whole day.
Overruled. You can answer.
As per Mr. Salas, the residence was empty. It was just him in there.
When you talked to the sergeants, was there children observed in the truck?
No, it was just him in the vehicle.
During your conversation with the sergeant, was there any children in the vehicle with Mr. Salas?
She did not mention children.
Did you observe any children in the home of Mr. Salas?
I did not.
You testified earlier about an October date. Is that right?
Yes.
Did you have knowledge about that?
Yes, I did. I looked up his history on the mobile computer terminal and I saw his history.
Okay. But you weren't there on the scene.
No, I wasn't.
You just looked at the history.
Yes.
Besides that, you know nothing about that.
No.
You didn't know if the children was with him at that time.
The documentation did not mention children.
You didn't know if he was operating a motor vehicle at that time.
No.
Now, officer, how do you conclude that someone's intoxicated?
If they refuse a standard field sobriety test, I conclude that they're intoxicated by the way they talk. If they slur their words, their stability. If they have a strong and distinct odor of alcoholic beverage emitting from their breath, and if they're making sense with their words. But usually when I do these arrests, they include a traffic violation that helped build my case. And in Mr. Salas' case, I didn't see him operating the vehicle.
But you never got to the field sobriety test either.
I did not. I didn't see him operating the vehicle.
You didn't, there wasn't any portable breathalyzer, or you didn't take him to the station for the intoxication 9,000.
Like I said, I didn't have enough probable cause to proceed with detaining or arresting him.
And officer, at the end of the day, what did you issue Mr. Hugo Salas?
At a later day, I communicated with Mr. Salas via phone, and he admitted to me via phone that he was driving that day. And I did let him know that his name would be included on the report and that he would be issued a citation for backing without, I forgot the exact name, but backing without safety.
Okay, and what is that? What kind of a misdemeanor is that?
That is a Class C.
That's a Class C. Is that a fine only, no jail time citation?
That is a fine, yes.
Okay, so does that conclude your investigation then?
If for whatever reason I wanted to continue the investigation, I could proceed with the warrants for driving while intoxicated and see if it be approved or not, based off his admission to me via phone that he was operating the vehicle that day.
But you just testified.
It would be a warrant, sir. I would have to present it and see if what evidence I collected would be enough to prosecute.
Okay, so the citation that you gave Mr. Salas does not end the investigation?
It does and it doesn't. In his case, I'm not proceeding with any further investigation, but there is chance like that it could continue. But in his case, I'm not going to continue it.
Okay, that's what we're chancing. But for Mr. Salas's case, you're done.
It's done.
All right. That's the witness.
That was cross-examination. Anything on redirect?
Just to clarify, was there any doubt in your mind on November 5th, 2025, when you encountered Mr. Salas that he was intoxicated? Any doubt?
No.
Thank you. No further questions.
Anything on recross?
No question.
Officer Escobar, thank you for your testimony. Any possibility that either one is going to recall for any purpose this witness?
Respondents have no, I mean, we don't have any more questions, Rob.
I think Officer Escobar was quite comprehensive and professional. Thank you very much for your time.
All right, officer, at this time, the court excuses you. Have a good night. Ms. Garcia, do you have any other witnesses?
Yes, next I call my client, Marcela Salas.
Ms. Salas, remind the court gave you an oath, right? Okay, you may have a seat here on the witness stand.
Judge, first, I'd like to take her on voir dire as to her supporting affidavit, Your Honor.
Sure, go ahead.
Can we cue Ms. Salas's supporting affidavit?
What case center number is it? Oh, I guess it doesn't matter because it's part of the court record. So either is it on case center?
I'm not sure, Judge.
Even if it
was filed
isn't,
with the petition, Your Honor.
you're so in this situation, it's not your evidence. It's part of the case file. So for purposes of this year, the court will allow it. Ms. Flores, if it's not on case center, just prompt it off of Odyssey if available. As that document is being prompted, Ms. Salas, just same instructions to you as all witnesses. Just listen to the full question before you respond. Pause for a couple of seconds. If one of the lawyers objects, just pause your answer and I'll let you know if you can answer. Do you have any questions?
No, Your Honor.
All right.
Thing on. Hello? Yes.
Just make it a full screen, please. If it's... Mr. Chu, go ahead.
Good evening, ma'am. My name is Nathan Chu. I represent Mr. Salas. Mrs. Garza, right? Ms. Garza, is that you want to be called Ms. Garza? Because I know you had your name changed after divorce.
Correct.
Okay, Ms. Garza. Were you present at the scene of the accident?
I was not.
So on page 3 of your affidavit, where you say that you reviewed the body cam footage and you learned this from watching the officer's body cam. Is that right?
Incorrect.
It says here, after reviewing the body cam footage, this is what I learned.
You're asking me if I learned about the accident through the body cam footage? That's incorrect. I
Okay.
learned it through Mr. Salas.
Okay, if you look at the page 2, page 3 of your supporting affidavit. Okay. Are you seeing that?
Yep.
Okay, and it says there in your affidavit, in reviewing the body cam footage, this is what I learned.
Can we point to the line, Judge, so that she can see better?
It is. It's been prompted and pointed.
So this,
That is correct.
okay, this is what you learned after reviewing the body cam footage.
Yes,
Okay, that Mr. Salas passed through the entrance, that he reversed back behind the vehicle causing injury.
correct.
This is nothing that you witnessed.
I did not witness.
Further on, that Mr. Hugo Salas refused to stop, that the female victim approached the vehicle, that she took a picture of him. You did not witness that.
I did not.
That she stated that he was intoxicated, that he had fled the scene, that the female victim had called 911 at 5:52 p.m. You did not witness that.
Again, Mr. Chu, I did not witness that.
That the female victim provided Officer Escobar with pictures, took a Hugo. You did not witness that.
As it states in the affidavit, I witnessed it through the body cam footage.
Okay. Your Honor, I ask the court to strike page 3, page 4, all the way up into the middle of page 4. Ending with, had I known.
Responsive any or pre, excuse me, not pre. Anything on cross?
Ms. Salas, did you write this statement? You said it was a summary, correct?
Correct.
And the body cam video has been introduced into evidence, correct?
Correct.
And all the statements that Mr. Chu has repeated to you for you writing has already been admitted into evidence, correct?
Correct.
So everything that you said is in fact correct based on Officer Escobar's testimony and the admitted evidence of the body cam footage, correct?
Yes, that is correct.
And there is nothing different between what is stated in your affidavit and what is represented in the body cam footage, correct?
Correct.
Isn't it true that you took great pain to be very specific, honest, and thorough about what you saw in the body cam footage?
Objection leading and bolstering, Judge.
Sustained. Don't answer. Anything else or any other
That's
questions?
all, Judge.
Judge, this was all done before the officer testified, before the evidence got in. This was used for the ex parte request to suspend my client's visitation, Your Honor. This was not her language. This is not something that she was a factual witness to. That's the reason why we asked for it to be stricken, Judge.
Judge, affidavits for ex parte temporary restraining orders for extraordinary relief are very often based on activities, incidences that a person may not have witnessed firsthand, but has had firsthand knowledge about after summarizing it. That is what occurred here. And we need to go on further down because my client did go to the scene at about 7 o'clock that night, and the court has not been able to elicit that testimony and find out what she knows with regard to that.
All right.
So
All right, overruled and subject to bringing up the same objection at any time in the future. All right, This is direct examination. Go ahead.
May I continue with the witness, Judge?
Yes.
Thank you. Ms. Salas. What happened on November 5th, 2025 that prompted you to file this modification?
I saw Mr. Salas in person, completely wasted and completely with complete lack of accountability for what had just happened.
Okay, before we go any further, why were you at Mr. Salas's residence on November 5th, 2025?
We had agreed earlier that he would lend me his Toyota pickup truck so that I can move personal items from my house to my parents' house.
When did you make these plans?
Earlier that same day,
What time did you and Mr. Salas agree to meet at his residence for you to pick up the pickup truck?
around 7 p.m.
Did he at any time call you to tell you that you could not pick up the vehicle because he had been involved in an accident?
Objection leading and
So-
relevance.
Sustained as to leading, overruled as to relevance. So don't answer, but you can rephrase or move on as you wish.
Before you arrived at his house, did you receive any phone call from him?
Objection leading.
Overruled.
No,
Was there anything that led you to believe that you should not go to his house to pick up the vehicle?
Objection speculation.
So don't guess, don't speculate. If you have an opinion, you can certainly give that on that basis. Overruled, you may answer.
no, I continued with my day and went directly to his house as we had agreed.
Okay. When you arrived at his residence, what time was that, more or less?
It was around 7:30.
When you arrived at his residence, please describe Mr. Salas's affects, his disposition.
He was wasted to another level. He had a long neck mirror light in his hand, and he was pretty much finding the whole situation very funny.
What did he tell you about the incident?
The moment I got into his residence, he said, "You're gonna freak out, but they took my truck away." And I literally went cold in fear.
What explanation did he give you as to who took his truck away and why?
He started laughing. He said, "Nothing happened. My attorneys fixed everything. Nothing's happened. I hit a parked vehicle and my attorney fixed everything. Nothing's gonna happen. It will be fine."
What happened next?
I was in complete shock. I couldn't understand how he wasn't arrested. I told him, "You're wasted. Why aren't you in jail? I can't believe that you got your attorney to cover this. This isn't funny. It's serious. Like, you have a real problem." I took the beer from his hand and dumped it in the sink. And I saw that his fridge was full of more beer. I was like, "I'm not gonna dump all of them, but you have a real problem." And 2 minutes later, the doorbell rang, and it was the police officer. It took me by great surprise.
Objection narrative, Judge.
Sustained.
Once Officer Escobar arrived, what did Mr. Salas say?
He asked if the girl was fine.
So was this different from the story he had given you before that he hit a parked car?
Completely
Objection
different.
leading.
Overruled. You can answer.
Completely different. And it shocked me even more that there was a girl actually there. And the concern of her being fine was very shocking.
What was your reaction when you heard this?
I was speechless. I couldn't believe that he had told me it was a parked vehicle.
How did this incident change your mind and encourage you to file this modification?
It changed everything substantially and materially immediately.
Why?
my biggest factor is, again, his demeanor, his lack of accountability, his lack of moral compass, his lack of acknowledging that he had done something wrong. That for me was the thing that most triggered his mortifying concern that there's terribly no way to help him.
During your marriage, in your opinion, having lived with him for over 12 years, do you believe he had a drinking problem?
Objection, Judge, judicata. This is a modification. The divorce has already been finalized, Judge. Those are information that was during the marriage and it was already closed up.
Judge, he's saying that there is no evidence that he's an alcoholic whatsoever. I'm trying to lay the foundation and then establish a material and substantial change,
But Judge,
as is my burden,
but still,
before and after.
Reply.
but still, Judge, during the marriage or during the culmination, the settlement and the final divorce, none of those issues were brought up.
Mr.
So
Chu,
bring up the past to try to bootstrap what they're trying to do today. That's
Give me a second. Let me give me a second, folks. Let me think about this because the objection is res judicata. That solves any and all pending legal issues. The question here is not one of law. The question is one of fact.
this isn't res
Let me
judicata. There
continue.
wasn't a cause of action
I
with
understand.
regard to his
I can't think
alcoholism.
when people are talking. Just
I'm
give me a
sorry.
second.
May I say something, Judge?
Go ahead.
In res judicata, those are causes of action filed for which you seek a remedy. In family law, what Mr. Chu is leading to is if there was ever an accusation of abuse, neglect, alcoholism, if you took care of it in a divorce, any future allegations are res judicata and cannot be brought up. That flies in the face.
I
of the
tell you what,
public
folks, this
policy.
is how the court is going to see this. The court is going to see this as in this light, understanding that if true, then that would be a cause for concern. Any and all causes of action in that event would have died or been extinguished at the time the final decree of divorce was filed. So the court is going to overrule the objection with this limited exception. Any testimony provided by this witness will not be determinative or dispositive, but the court will lay its decision based on the information provided from the date of the signing of the decree forward. But any and all things factual, not legal, will be allowed. Overruled, you may answer.
What was the question?
Let me back up a little bit. When did we settle our differences with the mediator, Marty Cigarroa?
August 27.
Okay. When did we come to court with Judge Villarreal for a hearing on attorney's fees? The one issue that we couldn't agree on at mediation.
I think it was the next day.
I'd ask the court to take judicial notice of its docket, Judge. I believe that was September 29th.
Oh, yes, September.
Court will take notice.
This incident occurred between the time that we settled our differences and we were able to file the divorce decree, correct?
Correct.
Okay. Let's get back to his alcoholism. I asked you, during your 12 plus years marriage, in your opinion and based on your daily interaction and relationship with Mr. Salas, do you have an opinion as to whether or not he has a problem with alcohol?
I resume the objection again, Judge, for the main fact is that they're trying to use something that was during the marriage, which was closed up, to try to use it as material changes for the present modification.
Judge, may I clarify
Yeah.
family law 101 and the
No,
burden I
no,
have for
no, you may
modification?
not overruled, and the court will consider that a running objection.
Thank you.
Proceed.
Yes, I have an opinion that he has
Objection.
a problem.
Also, she's not qualified to give a professional opinion. She hasn't been presented as an expert in this field, Judge. She can give, but something like this requires an expert opinion. So I object on that answer, Judge.
Your Honor, Rules of Evidence, Rule 901 provides for lay witness testimony based on their personal interaction and experience.
Overruled, you may answer.
He would constantly drink. Practically halfway through our marriage, it was daily.
At what time would he begin drinking?
Around the afternoon, and he would get home late. He never admitted that was what he was doing. He was always working late.
What behaviors did you notice to lead you to believe that he was drunk?
After 12 years of living with him and seeing him drink almost daily, I can catch how his voice changes, even through phone calls. His voice rises, he gets aggressive, he slurs his words, he makes no sense with the words that he says. And if you see him in person, he doesn't walk straight, he doesn't look straight.
How many days out of the week would you surmise, in your opinion, based on your interaction with him in your 12-year marriage, that he drank out of the week?
Objection, Judge. Again, relevance. We've already, I don't know how long they're going to stay on this route, Judge. It's already been determined he drank during the marriage.
Overruled, but I don't know if that's a concession. You just want to move on.
Okay, I will move on. This incident occurred, as you testified, between the time we settled and between the time we were able to file the divorce decree. Is that correct?
Correct.
Now, were there any terms that we agreed to in the mediated settlement agreement that addressed Mr. Salas's drinking or any prohibitions, restrictions with possession or access concerning his drinking?
Judge, objection leading, and second, that's part of the negotiations, Judge.
Honor, what's the
Sustained as to leading, overruled as to the rest.
Did the parties agree? Let me back up. Everything that we agreed to in the mediated settlement agreement in August is reflected in the final decree of divorce, correct?
Correct.
In the final decree of divorce, which is public record, is there anything that addresses his alcohol use?
Objection vague.
Overruled.
No.
Why not? Why didn't you insist on this when we settled this matter?
Objection, Judge. This is speculation. It's outside the four corners of the document that we submitted to the court, Judge.
Jesus Christ, Judge, my
Overruled as to speculation. If you know, you can give the answer. If you don't know, you should just say you don't know.
Judge, I object to the sidebar, Your Honor.
Sustained.
I personally spoke with him
Judge,
several times.
did you
And
say
he
sustained
asked,
or overruled?
and
As to the sidebar that was made, that was well taken and sustained, but you can answer.
he personally promised that he was gonna get better. That I should give him a chance. That he really wanted to stop drinking. And I have never, ever, in these months of trying to get the divorce, have I ever not wanted him to be with the girls. I have even told him multiple times that he can see him any day. Doesn't matter if the order says certain days or certain weekends. I have insisted that he can see him every day. He can go and have dinner with them every day after work instead of going to the bars. And he promised that he wanted to get better.
Was this the circumstance at the time that you settled this case and came to an agreement with regard to the final decree of divorce?
Objection leading, Judge.
Overruled.
Correct.
Okay. How did the incident on November 5th change materially and substantially the circumstances of you, your husband, your ex-husband, and the children to
Objection,
lead you to file this modification?
objection, Judge. That is the incorrect legal standard. It's the material and substantial changes of the children, not the movement.
Well, I mean, the legal point is well taken, but if the question is asked and answered, it may not move the needle if you're right. So overruled, you can answer.
It changed more than significantly because, like I said, again, he had lack of accountability. He thought it was funny. He wanted to get it covered up and not take any responsibility for it. He wasn't even concerned for the woman. And he lied to me about what happened. He said he hit a parked vehicle. And he had just promised that he was going to try to be better.
Why does a hit and run accusation concern you?
Judge, speculation, objection.
Overruled. If you have an opinion or you have an answer, you can give it.
It concerns me because if my daughters are with him at any point and he's constantly drinking, they can be in an accident, they can die. They could end up in the hospital. If he hits someone and runs away, that other person might pursue them with a weapon. And I cannot take that risk.
After you review the body cam footage and also hearing the officer's testimony with regard to his prior stop on October 1st, what concern do you have?
The body,
Judge, the object to that one, she's testifying to knowledge that's not hers. The officer's already testified to what he did and the body cam, Judge. She's just,
Tell me the specific question.
I asked her why is what she learned from the officer's testimony in the body cam footage about his stop on October 1st concerning to her?
so asked an objection, also asked and answered. She's already told the court that it's concerning, it's shocking, it's
October 1st, not November 5th.
Different.
and
Overruled,
also
you can answer.
objection again, Judge. That's something that's not within her knowledge. I mean, that's something that she's learned through hearing the testimony, Your Honor.
Credible testimony.
Overruled, you can answer.
what made me even more sure that my daughters are in danger is finding out that he had this history, that he had to be called by the people from Deutsch and Deutsch to leave the premises because he was wasted.
Again, Judge, she's
And
testifying.
it
to
was on a
something that she has
Wednesday?
no
Give me one
knowledge
second.
of.
Let me hear the objection. What is the objection?
Objection, again, speculation, Judge. She's summarizing, she's testifying to something that she has no knowledge about. And she's just giving an opinion on something that she has no knowledge about yet.
Overruled, but I've heard the answer. Let's move on.
I do have.
Just stop.
Sorry.
Question.
What is special about October 1st?
I do have evidence because I saw him that day. It's my daughter's eldest birthday. He came to the house to drop off the bracelet he bought from Deutsch and Deutsch, and he was wasted. I told him, please leave. I had previously invited to dinner. When I saw how wasted he was, he couldn't even walk. I told him to leave the house, and he was definitely not going to go to dinner.
What time was this?
In the afternoon.
Was the sun out?
Yes, it was still light out.
Did he ever tell you anything about the cops being called on him to Deutsch and Deutsch?
Never.
Do your children know? Have you ever talked to your children about the concerns with Mr. Salas's alcohol intake?
I have recently found the need.
Objection calls for speculation, Judge.
Overruled. She should know the answer.
I have recently have found the need to start talking to my daughters about what drinking is and what alcohol can do to your brain and they have become, for the first time in their lives, aware of the subject.
Have you told them anything about Mr. Salas's alcohol consumption?
Yes,
What have you told them?
he recently delivered his pickup truck as decreed, and the girls wanted to know why parts of the truck were missing and broken. And I told him because father had crashed while being drunk.
Did we try to reach out to Mr. Chu and Mr. Salas to try and settle this difference after the November 5th incident?
Objection, Judge. That's a confidential settlement communication between the lawyers.
Sustained. Don't answer. Move on.
Did you confer with Mr. Salas to try and come to agreements so that we could avoid this coming to court now?
Yes,
Do you remember what day that was?
November 7th.
What did you all talk about?
I told him that all he needed to do was accept the terms I was asking to modify, that I did not want to go to court. He declined.
And that was before we were able to get the divorce decree filed, correct?
Correct.
Had we come to an agreement, this modification wouldn't have been necessary, correct?
Objection leading, objection, confidential attorney, settlement communication, Judge.
Sustained as to the first, overruled as to the second. Don't answer.
I'll go back, Judge. What is it that you're asking the court to do today to for a temporary injunction in the meantime, until we can further investigate and have a final hearing in the future? What do you want to happen right now?
I still want him to see the girls like I always have, but I wanted to be with me around supervising. I want him to not drink before and during and not drive them. And if there needs to be a breathalyzer.
Do you think your daughters are in danger under the current terms of the divorce decree that have no restrictions with regard to his drinking?
Objection leading, objection speculation, Your Honor.
Sustained as to leading, overruled as to speculation. Don't answer.
Do you have concerns with regard to your daughter's safety when they are in Mr. Salas's possession?
Objection calls for speculation, Judge.
Overruled, you can answer.
Most definitely.
Please explain what concerns you have.
I'm concerned that he might not be functioning correctly due to alcohol. And he might get them in an accident while driving, or that he might pass out while he's with them at his house, or just basically not know what to do, the right care for that they need while they're with him.
Before your discovery of the November 5th incident and the October 1st incident, were you aware of any other traffic stops of Mr. Salas by the LPD for any reason?
No.
What do you think is in the best interest of your daughters going forward?
It is definitely in their best interest that he has restrictions until he's able to demonstrate that he's gonna take his word and not drink while he's around them.
I'll pass the witness, Judge.
Cross-examination, Mr. Chu.
Ms. Garza, on October 1st, 2025, did Mr. Salas have the children with him at Deutsch and Deutsch?
No,
On November 5th, did he have the children with him?
No.
Did you have the children?
yes,
Where were the children?
They were in their dance class at Laredo School of Contemporary Dance.
Now, since the signing of the order by the court on December 5th, Mr. Salas has not been able to see his children.
Correct.
Now, that's only not seeing his children. Did you also instruct the children not to pick up his phone call?
He has been communicating through phone, FaceTime, and text messages with the girls on a daily basis.
He has or he hasn't?
He has.
And he's able to do that.
He has been doing it every day.
Okay. Now, do you remember the final order that you agreed to? And that was pronounced on the record in open court and also later signed by this court?
Objection, it was never pronounced in open court.
Had it read into the record, it was pronounced divorce until we were able to get the final order signed, Judge.
Well, it was pronounced. I mean, I presume it was, but I don't know.
Maybe I'm
I
wrong.
can, I
Judge.
can take judicial notice, but give me the date, Mr. Chu.
It would be September 29th. That's the date we had our hearing on attorney's fees.
But prior to that, we presented the settlement, we presented the agreement, and the court orally rendered the parties divorce.
Would have been September 30th. I don't recollect, but I would be
Okay,
very surprised if I didn't. I tend to do that in every single case, subject to
we'll
other
take that, Judge. We'll
other
take
legal
that.
ramifications, but I presume that I did. I can't say definitively that I didn't. You may proceed, Mr. Chu.
And in that divorce order, and also in the settlement, you agreed to a loving and caring order. Is that correct?
Correct.
And that loving, caring order instructed you not to talk negatively about Mr. Salas.
Objection,
children.
relevance, Judge. This has not, they have no live pleadings set for hearing today, Judge. There has been no allegation or request for modification set for today that has anything to do with that. What's relevant.
The objection is relevance. What is the response?
It's relevance as to the children, Judge. I mean,
You're right, but what specifically? I mean, what's relevant to the children and with regard to the issues before the court?
the fact that she's disparaging my client with the children.
Same as before. I'm going to give you a little bit of leeway and then just move on. You may answer.
What is the question?
The question is that you agreed to a loving and caring order. Do you remember that?
Yes.
And that order provides that both parties would work together to raise the children. Correct?
Yeah.
And not to talk bad about the other party.
Correct.
And yet you did when you said that Mr. Salas wrecked the vehicle because he was drunk.
That's not talking bad, it's just a fact.
That's the witness, Judge.
That was cross. Anything on redirect?
No, Judge.
Ms. Salas, you may step down. Ms. Garcia, do you have any other witnesses?
Mr. Salas.
Mr. Salas, approach the bench and remind the court. Did the court give you an oath earlier?
Yes.
All right, you may have a seat.
Mr. Salas, where were you in the afternoon on November 5th, 2025, before your accident with Miss Brown?
In the afternoon, I was at the office.
Are you denying that you were at a bar drinking, or do you drink at your office?
No, I was at the office in the afternoon, and then after the office, I went to meet a client.
And you drank with your client?
No, I did not.
Are you denying that you were drinking at any time on the day of November 5th, 2025?
Yes,
And you want the court to believe you over Ms. Salas's testimony, Ms. Brown's statement, and Officer Escobar's statement, correct?
correct.
So you're the only one telling the truth today.
I do not drink.
Okay, so you went with a client. Where did you go?
I went to a office bar and grill.
Office Bar and Grill,
Yes,
the CD one behind Palenque Grill on Loop 20?
that is correct.
Okay. How many hours were you there?
Oh, to the office, maybe about an hour?
So if you were there for an hour and you were drinking and
Objection,
caused an
relevance, Judge.
accident.
So don't answer the question. Let me hear the full question, then I'll hear the
if you
objection
were- Yeah, I'm sorry, Judge.
question.
If you were drinking for an hour and then had an accident, would you agree with me that you were drinking heavily?
Objection, relevance, Judge. We've spent the whole time here. I've not heard of anything concerning the children, Judge. We've heard about his accidents. We've heard about what the officer testified to, and now we're going to continue
So it's overruled,
examination on it.
overruled as to relevance, so you can answer.
At the bar, I was not drinking.
Would you agree with me that drinking for an hour would lead someone to believe that you had to drink a lot if you caused an accident later on? Yes or no? You agree with me?
No, I don't agree with.
How long do you think a person needs to be drinking in order to be intoxicated enough to cause an accident and take off?
I do not know the answer to that scientific question.
You do admit that you hit Miss Brown and left the scene, correct?
Objection, Judge, at this point in time, I'd advise my client that he has a Fifth Amendment right to not incriminate himself. The officer testified that the investigation may be ongoing.
And the officer already testified that he admitted it to him on the telephone.
Well, I'd still have my client assert his Fifth
so-
Amendment right not to incriminate himself.
Right, move on.
If I would request your credit card statements, were you paying for your client at the Office Bar and Grill? And will your credit card statements reflect that?
My client paid for the bill.
And who is your client?
That's confidential.
That's not confidential, and I would ask the court to insist that he answer the question. There is no proprietary information, confidentiality. He's a CPA judge,
Objection,
Yeah.
relevance, Judge.
because he's going to be someone that I'm going to subpoena next.
So there may be confidentiality, but it just doesn't apply in court unless there's a sustainable objection. If there isn't one, then you should answer.
Objection, relevance, as to this temporary order proceeding, Judge.
Relevance as to this proceeding.
I'd like to know who he was with. If he says it's a client, then we'll be able to verify later on if it was.
Judge, once again, this is a temporary order proceeding. She's doing trial on the merits, Judge, so we object to the relevance.
Sustained. Don't answer.
Would you agree with me that the children could be in danger if you're driving under the influence with them?
Yes, I would agree with you.
Would you agree with me that leaving the scene of an accident could also be dangerous to your children if they were in the vehicle with you?
Yes, I do agree with you.
Okay. Do you think that you need any restrictions with regard to your visits with your daughter based on your alcohol consumption?
No, I don't believe that. I believe that I've always been a responsible parent. My
Yes or
children-
no?
My
Yes,
children
or
have
I'm not
never been.
asking objection, non-responsive, yes or no?
You can answer. Go ahead.
Can you repeat the question again?
Do you believe that you need restrictions with regard to your alcohol consumption when your daughters are with you?
No, I do not believe that I need restrictions.
When we were here the first time in court back in January, February, you did not take a urinalysis test, correct? Yes or no?
Objection, Judge, that's.
Yes or no?
Objection,
the
again,
objection?
Judge. That's relevance, number one. Number two, that it was res judicata facts that was already closed up at the divorce, Judge. It's not new information for this temporary order hearing for this modification, Your Honor.
Overruled. You should answer.
I took a drug test.
No,
and
no, no.
yes,
In court, did you take a urinalysis test? Yes or no?
yes. Oh, no, I did not.
And you claim to have taken a drug test at Laredo Examiners, correct?
correct?
And in the divorce decree, you were supposed to provide that result to my client, correct?
No,
You're not supposed to provide.
no. And
Have you
ma-
ever
may I-
provided any results to Ms. Salas or the court regarding your alleged drug test with Laredo examiners?
May I answer the question?
I'm asking,
Okay, great.
where is it?
So-
Have you ever?
So I took the drug test as required because it was actually sent by your office, by Mrs. Lanes's office. She made the request, and I took the form to the lab, and the lab told me that Ms. Lanes and Mr. Esturgio would be the only ones to be able to request that test.
My question is very clear. Did you provide the results to the court, to Ms. Salas, either personally or through an attorney?
No, I did not.
You were also ordered by this court to go to alcohol treatment. Did you do that?
Yes.
With who?
I don't remember the name, but
Where
I
are your
do
certificates?
we did provide them
To who?
to my attorney, Esturgio Perez, my prior
Judge.
attorney.
Objection again, relevance. This is all stuff that was done before the final divorce decree, Judge.
No, overruled.
Your Honor, I do want the court to bring up the divorce decree.
Ms. Flores, you can prompt.
I think it's on case lines. It's number 16 on my case lines. If we can go to page 44. Where it says hair follicle drug test. Can you read that for the judge?
Me?
Yes.
Okay. The hair follicle drug test. It is ordered that the respondent deliver to petitioner a copy of the results of the hair follicle drug test the respondent took with the Laredo examiners no later than the date after the court signs this agreed final decree.
When did the court sign this final decree of divorce?
The 25th of November.
Did you give her the hair follicle results at any time between then and now? Yes or no?
No, I
Okay.
did not.
Okay, let's go to October 1st. Did you drive to Deutsch and Deutsch?
On October 1st, I don't recall driving to Deutsch and Deutsch on October 1st.
Did you hear the testimony from Officer Escobar that there was a history pulled up from your driving record during his investigation? And he saw that there was a call by Deutsch and Deutsch regarding you for being belligerent and drunk. Did you hear that testimony?
Yes, I did.
Okay, were you at Deutsch and Deutsch on October 1st?
I don't recall it was October 1st, but I was at Deutsch and Deutsch.
Isn't it true that you purchased a bracelet for your daughter from Deutsch and Deutsch for her birthday, which is October 1st, 2025?
Yes,
But you're saying today that you don't remember if you were actually there that day.
exactly. I don't remember if I purchased it on her birthday or prior to her birthday.
Okay. On October 1st, when you were at Deutsch and Deutsch, do you admit that you were at Deutsch and Deutsch on October 1st?
I admit that I was at Deutsch and Deutsch.
Do you admit that an officer was called because you were behaving erratically?
I will admit that there was an officer called. Yes.
Okay. Would you admit that you were behaving erratically?
No.
Were you drinking that day?
Objection, relevance, Judge.
Relevance.
Judge, it's in the afternoon before he went to my client's house.
Overruled. You can
And-
answer.
No.
You had not drank that day.
No.
Did you go to any bar prior to going to Deutsch and Deutsch?
No.
You heard my client's testimony. that she did not allow you to go to your daughter's birthday dinner because you were wasted. Do you dispute that?
Yes,
So everyone is lying in court except for you, correct?
not saying that.
When do you drink?
When do I drink?
Yes, what days out of the week do you drink?
Whenever I meet with clients,
And how often do you meet with clients?
whenever we meet, it could just be Tuesday, could be a Thursday, could be a Friday,
So your testimony is that you only meet with clients at bars
or restaurants.
or restaurants, but there's always alcohol involved, correct?
Not always,
But usually.
not always.
Do you dispute my client's testimony that pretty much every night of your marriage, you would come home wasted after having met with clients during the day?
Yes, I do dispute that.
Would you agree with me that if you arrived at my client's house on your daughter's birthday on October 1st, on a Wednesday, when the sun was still shining and you were wasted, that could be a problem with alcohol, drinking in the middle of the afternoon, being wasted by the time you arrived at her house? Would you agree with that?
I would agree if that was true.
But you dispute that because everyone's lying but you, correct?
No, I dispute that because that did not happen.
Who is Erica that picked you up from Deutsch and Deutsch on October 1st?
Objection, relevance, Judge.
Relevance.
Erica?
Yes, do you admit
what
that
is-
a
what is the
person named
relevance?
Erica picked you up from Deutsch and Deutsch?
There's an objection as to relevance. What is the relevance?
The fact that he was actually picked up and was not operating a motor vehicle.
Overruled, you can answer.
Yes, so the officer just said, hey, they made a complaint, just to be on the safe side, just get a friend to pick you up. And I said, you know what, officer? I'm not intoxicated, and I just prefer to have my friend pick me up.
Okay, and what's her last name?
Erica Luna,
Okay, your girlfriend?
no friend.
So when the cops arrived on October 1st, what did they tell you?
Objection, relevance, Judge.
Relevance.
Judge, this was a call that Officer Escobar testified. He reviewed the call notes with regard to that call, and that employees from Deutsch and Deutsch called the cops because there was a belligerent person, Mr.
No,
Salas.
overruled, you can answer.
Well, which I find it strange because
Objection non-responsive. What did the police tell you when they showed up on October 1st to Deutsch and Deutsch?
that after I purchased the jewelry, there was a complaint on my way out, and that he was called that if I was okay, and I said, yeah, I'm okay.
A welfare check.
No, I'm okay. And said, well, they complained that maybe you might have been drinking, and I said, no, I haven't been drinking. But he's like, well, I'm not gonna let you drive just because they complained. And I said, okay, I'm fine to drive, but if you feel that it's gonna be an issue and I don't want any issues, I'm just gonna have my friend pick me up.
Did you drive to Deutsch and Deutsch?
Yes, I did.
And do you agree with me that you went to my client's house to visit your daughter and drop off a Deutsch and Deutsch gift after you went to Deutsch and Deutsch that day?
No, I do not agree with it.
What time did this incident occur at Deutsch and Deutsch?
Objection, relevance, Judge.
I don't recall the time because it's
So remember, if the lawyers object, you need to stop.
yes.
Relevance is the objection. What's the response?
I want to know what time he was at Deutsch and Deutsch. My client testified that he went to her house around 7 o'clock that night.
Overruled, you can answer.
At what time I was at Deutsch and Deutsch? I probably would have been at 4 p.m., maybe
Okay.
5. I'm
So-
not sure.
Would you agree with me that if you were intoxicated, that could be cause for concern for an adult to be drunk at 4 or 5 in the afternoon on a Wednesday on his daughter's birthday? Would you agree with me?
Would be a cause for concern?
Yes or no?
Yes, I guess.
Okay.
Yes.
Did you drive to Deutsch and Deutsch?
Yes.
When Erika picked you up, did she take you home?
Yeah, she took me home.
How did you get back to your car?
how to get back to my car.
Yeah.
Objection, relevance, Judge.
Overruled, you can answer.
Um, I guess she gave me a ride. Well, I'm trying to think.
You don't remember, do you?
No, well, I'm trying to think because it's something I hadn't thought about.
Well, it would be something remarkable because the cops had just gone to a public place because of you. Wouldn't you
Right.
agree that that would be a remarkable circumstance?
well,
That would, I would remember it, wouldn't you?
no, I do remember now. So Deutsch and Deutsch is a block away from my house, and I just walked.
And then you drove to my client's house, didn't you?
No,
How did you get to my client's house on your daughter's birthday on October 1st at 7 PM?
again, I was not intoxicated when I was not intoxicated. So if I did, it would have been driving.
In 2025, what other times other than November 1st and October, I'm sorry, what other times other than November 5th and October 1st have you been pulled over by any law enforcement agency?
Objection, relevance.
Overruled, you can answer.
Besides October 1st and November 25th, never.
In 2024, how many times have you been pulled over by any law enforcement agency?
Objection, relevance, Judge.
Overruled, you can answer.
None that I remember.
In 2023, how many times were you pulled over by any law enforcement agency?
Objection,
that I
relevance.
And this was driving
Right.
Objection,
Um,
relevance.
between 2020.
So I'm gonna instruct you, so your lawyer has been objecting, but it's already on the record because you're answering before I can rule.
Oh.
Next question.
Have the cops ever stopped you in public places for accusations of public intoxication?
Objection, relevance.
You can answer. Overruled.
No,
Ever?
yes, never.
Okay, and I'm just letting you know that we filed a public records request, so we will get that information. Why didn't you tell my client about the October 1st incident at Deutsch and Deutsch?
Because we're not in speaking terms.
You were not in speaking terms on October 1st of 2025?
Yes,
Did you hear my client's testimony that she was working with you and was hopeful that you had talked about doing better with your drinking? Do you deny that?
well, so this is my answer to that. I don't deny that we haven't been, we were talking, then we were not talking. So I'm not sure exactly where we were in that point in our separated relationship.
She invited you to dinner on your daughter's birthday, is that correct? Before you arrived at her house?
I don't remember having an invitation.
Isn't it true that you invited her, you suggested going to Noble that night?
Yes,
But you agreed that you did not go to your daughter's dinner afterwards, after you arrived at her house, correct?
correct,
And she did not let you go, correct?
correct,
But prior to your arrival, there was the conversation, making plans together as a family. Isn't that true?
correct.
Are you opposed to having a restriction during your periods of possession with the girls, prohibiting you from drinking alcohol while they are with you? Yes or no?
Yes,
Why?
because I do not drink when I'm with my girls.
Do you have any objection to, based on the accusations on November 5th, based on the accusations on October 1st, just to minimize any risk and put this all to bed, for you to have a breathalyzer in your vehicle when driving your daughters around?
Yes, I do object to that
Why would that be bad for your daughters?
because I've never placed my daughters in danger. I'm a responsible father when I'm with them, and I do not drink when I'm with them.
So why not have court-ordered restrictions just to be on the safe side, given what has happened that we know about on November 5th and October 1st?
Because it's not a pattern. And to me, one thing is for me to test, one thing is for me to test positive in a alcohol site exam test. The other thing is I've never had a DWI. I've never been arrested.
Don't you think you're lucky?
No, that's just because that's not an issue. I don't drink and drive.
When you leave bars and restaurants after meeting with clients in the afternoons, do you drive your own vehicle home?
Yes, I do.
Okay. Don't you think it would be best for your daughter's safety to make sure that we never put them at risk after you're drinking on Thursday nights when you pick them up for dinner? Yes or no?
And I guess I would say yes.
Don't you think it would be in their best interest to make sure that we do everything possible to secure their safety when they're around you, given the events of November 5th and October 1st?
No.
And we should trust you because you're honest.
Yes.
And you're the only one today that has not lied about your alcohol intake, correct?
I have not lied.
I pass the witness.
Cross-examination, Mr. Chu.
Good evening, Mr. Salas. Mr. Salas, on October 1st, did you have your children with you?
No.
On November 5th, did you have your children with you?
No.
Have the children been with you in your vehicle if you had been drinking?
No.
Pass the witness.
So
What,
is it your only,
Give me
my
one second,
apologies.
Mr. Chu.
when was the last time you were able to visit with your children?
The last time was about maybe 2 weeks ago.
Was it December 5th?
I want to say, no, it was actually during Thanksgiving. The Thanksgiving holiday weekend.
Okay, but after that, were you able to visit with your children?
No.
Were you able to exercise your rights with your to visit with your children?
No.
And are you able to communicate with your children daily?
Yes.
And what is your goal today? What do you want to do?
My goal today is to establish that, for one, I am a responsible father. I've been for the last 12, 13 years. I've never had an issue. I don't have a DWI. I do not drive intoxicated, and I do not drive, and I do not drink and drive with my girls when I'm with them. The other thing is, I do care for the safety of my children, and that isn't my number one priority.
Okay.
But at the same time, I think that what Mrs. Garcia proposes, it's too harsh for someone who doesn't have a record of having DWIs, of not getting citations for intoxication. Also, like I said, yes, I do go with clients to businesses, to their business, or I will go to restaurants. And yes, that's part of my business. It is to socialize. Now,
But hold on, but when you're socializing, do you have your children with you?
no,
And part of that, is that what you base your income on?
correct.
Now, do you miss your children?
A lot. I miss them a lot.
Because the order says you cannot see them until further orders by the court. Is that right?
Correct.
So how many weekends have you missed already?
At least, I guess, after Thanksgiving weekend up to now.
Okay, so the 12 years that you've been married to Miss Garza, have you put your children at risk?
Never,
After the divorce, has any point in time, have you put your children at risk?
never.
Pass away.
So is
That
it your,
was cross, redirect.
so it's your testimony that you only drink, that the only days that you don't drink is when you're going to be driving your daughters?
Yes, that is correct. So when I'm with my daughters, I do not drink before I pick them up and throughout the weekend or whatever day I'm with them.
So it's your, you want the court to believe that just the days that you have your daughters, you will refrain from drinking.
That is correct.
And so if I were to get your credit card statements and track all the restaurants and bars that you have charges for, those would not be on days that you have your daughters.
That is correct.
Okay, we will see. Do you think that only people that have DWI arrests are the only people that have alcohol problems?
Do I think that? No,
Is it possible for a person that has alcohol problems to have not been arrested for DWI?
possibly.
Is it possible for a person with alcohol problems to not have been arrested or cited for public intoxication?
Possibly.
I pass the witness, Judge.
Anything on recross?
No, Judge.
Mr. Salas, you may step down.
Thank you.
Judge, I was only calling these three witnesses, but I forgot to just want to proffer testimony with regard to attorney's fees myself. If you
Miss,
want to
Miss,
wait until
Miss,
the end of the hearing, Judge, we can do that.
let's wrap up, your case in chief. Just step up, in front of the, lower bench, in front of the microphone. And raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand, Ms. Garcia, go ahead.
I did file, and I want the court to take judicial notice of my filing. That includes an affidavit proving up my attorney's fees. And I also have an invoice with my attorney's fees thus far with regard to this modification, Judge. I will submit to the court that I have been a licensed practicing attorney for 30 years. I am familiar with family law. I've been practicing that for about 30 years, Judge. I'm personally familiar with the amount of attorney labor, attorney time, and attorney billing rates required or necessary to prosecute these types of modification cases through trial. I'm also familiar with the customary fee charged for services and litigation matters in Laredo. The hourly rates charged in this modification proceeding are reasonable and necessary based on my experience, reputation, and ability among the attorneys performing these services and the prevailing hourly rate in Laredo, Texas. I will submit that the invoice I provided is true and correct. It contains 16.40 hours of attorney time, reasonable and necessary expenses in preparing the pleadings, requesting public documents, talking to Laredo police officers, talking to the custodian of records for LPD, talking with my clients. And so I believe these are reasonable and necessary expenses for which my client should be paid, because we tried to work this out and were unable to, Judge. And so under this circumstance, my client is asking for payment of attorney's fees, and I'm only charging her $300 an hour when my correct rate is $350 an hour. Based on my experience, Judge, and my reputation and my abilities, that is more than reasonable. More than a reasonable rate. There are attorneys with less experience than me that charge much more than that hourly rate. My client, there are also costs in the amount of $299.18, Judge. These services were performed, they were reasonable, these costs were reasonable and necessary in the prosecution of this modification. This amount represents 16.40 hours of attorney time and 0.20 hours of legal assistant time. The attorney's fees incurred take into consideration the time and labor required, the novelty and difficulty of the questions involved, required to perform the legal services properly, the likelihood that acceptance of the particular employment would preclude other employment by the attorney because this was an emergency. the fee customarily charged in Webb County for similar legal services, the amount involved and the results obtained, the time limitations imposed by the client or the circumstances, given that it is a temporary orders proceeding, the nature and length of the professional relationship with the client, and the experience, reputation, and ability of the attorney performing the services, and whether the fee is fixed or contingent. In total, it is $5,234.8, but I would ask to add to that for the in-court time today. And I would at least put it at 5 hours, Judge. So that would be an additional $1,500.
Anything else with regard to fees? Cross-examination, Mr. Chu.
No question, Judge.
You may have a seat. Any other, wait, as you take your seat, any other witnesses, Ms. Garcia?
No, Judge.
Your first witness, Mr. Chu, if any.
Judge, we don't.
Brief closing, Ms. Garcia.
Judge, this is a modification. What is important here and the burden that we have is that there is a material and substantial change in circumstances with regard to a child or a conservator in this proceeding from the time of the divorce to now. This is an unusual circumstance because the parties came to an agreement with regard to Ms. Cigarroa in August, Judge. And then we had a contested hearing on September 29th regarding attorney's fees. So it was at that time that we were working on the final decree of divorce. Before it was filed, the incident with regard to November 5th came up. We tried to come to an agreement to modify the agreed terms of the divorce decree, but were unable to. So we had to wait until, and Mr. Chu can agree, there was no agreement, and I had to file the divorce decree in order to be able to file the modification. So under 156.101, the court may modify an order that provides for the may modify an order that provides.
Sorry, you're not talking about the rule. You're talking about the code.
Yes. And what we have to prove is that the circumstances of the child,
Sorry,
conservator, or
I'm
other
not there yet. So you said what? 150?
156.101. So it's our burden to prove that the circumstances of the child, a conservator, or other party affected by the order have materially and substantially changed since the earlier of the rendition of the order, and that it is in the children's best interest. In this situation, my client testified there was nothing in the divorce decree with regard to restrictions with regard to Mr. Salas, because they had an understanding among them that he was going to get better, he was going to do better, and she was having good faith in him. Trust to work better together as parents. My client even went so far, and it's demonstrative, Judge, that on October 1st, even a few days after the attorney's fees hearing, my client invited him in good faith for a family dinner for his daughter, unknowing that just earlier he had a run-in with the cops. Had this November 5th incident not happened and my client not been at his house, she would have never known. My client testified that the circumstances between the time that they settled this matter, and as Mr. Chu said, the court pronounced and rendered this divorce finalized. This incident on November 5th occurred. It changed everything for my client, Judge. Mr. Salas is harping on the fact, no harm, no foul. The children weren't there in the alleged hit and run that he admitted to. The children weren't there, should in fact he be intoxicated. There is a history within the court's record of him failing to produce a urinalysis, ordering a hair follicle test, and the results never being turned in. My client has testified with regard to the history of alcoholism that he has demonstrated. On November 5th, all of that changed. Her trust in him, their tacit agreement that he was going to be better, do better, and not drink the way he used to before, all changed when he hit a vehicle and took off. It is not safe for the children for them to say, the children weren't there, no harm, no foul. The children weren't there, no harm, no foul on November 1st or October 1st. Judge, my client is concerned that without restrictions and modifying and providing new restrictions temporarily until we can further investigate the depth and seriousness of his alcoholism, the children are at risk. The children are at risk should he have another car accident. What if he hits someone that has a gun? He was lucky it was an Army sergeant that would not have done that. What if the next time it's someone that has a gun and the girls are with him? Is he going to take off again? Your Honor saw the video. We didn't need smell-o-vision. You could tell that he was drunk. 40 minutes after the accident, he was wasted on November 5th. My client was there and testified. You heard testimony from an independent third party, an investigator, the Laredo police officer, no doubt in his mind, he was intoxicated. You heard the complainant, Miss Brown, an Army sergeant, testify that he was slurring his words, his eyes were drooping, he was intoxicated. You've heard from 3 people on November 4th that he was intoxicated, and that call came in at 6:52, Judge. So what was he doing in the afternoon on a Wednesday drinking? To be that inebriated, to drive away and not be concerned for who he hit, whether it was a serious accident or a minor accident. Do we really want to take that risk that the girls are going to be there the next time? Do we really want to take the risk that we're going to trust that only when he's with the girls, he's not going to drink? I wouldn't risk that with my children. No one in this courtroom would risk that with their children. My client is done risking that and putting her faith in Mr. Salas. She needs restrictions to be in there for the best interest of the children. The circumstances prior and at the time that they agreed to the terms of the divorce, and it was pronounced and rendered, were different. They had an agreement. Things changed materially and substantially when she found out there was a hit and run with him being intoxicated. And what's worse, not even on November 5th did my client know about the October 1st situation. It wasn't until she saw the body cam footage that there was a history. And we still didn't even know what that history was until Officer Escobar testified and said it was October 1st, his daughter's birthday. He was belligerent, intoxicated at Deutsch and Deutsch. And he went right after that to my client's house, wasted. So my client refused on their daughter's birthday. On their daughter's birthday, he could not resist drinking. We cannot take the chance that he is not going to drink and drive with these children. We cannot take the chance that he's not going to drink when they're in his possession and pass out. My client wants reasonable restrictions for the protection, safety, welfare, and best interest of the children. My client was unaware of his criminal activity on October 1st, and the hit and run changed everything, materially and substantially. For him to not have the presence of mind to stay at a car accident and make sure that the person he hit was okay, that he at least admit what he did at that time and take responsibility for a very serious condition. It is not good enough for the children to say they weren't there. There's no harm to the children. Do we really want to wait until there is an accident to get more restrictive orders and get serious about Mr. Salas's problem? Because he's not serious about it. Everyone is wrong but him. And it's a serious concern if he's meeting with clients at bars and restaurants pretty much on the daily. I don't know about you, but everyone I know meets with clients at offices. For these reasons, Judge, there is a material and substantial change regarding the children and their safety because of the activities and actions and true alcoholism for Mr. Salas that my client wants him to get well for. She wants him to get help. She testified. She wants him to have access to the children, but it needs to be in a protective environment with serious conditions. That is why my client is asking that, number one, he have supervised visits temporarily until we can get a guardian. I requested a guardian ad litem, Judge, in my pleading. I would ask that a guardian ad litem be appointed. We will be conducting discovery to flesh out and investigate his history. But until that time, we do want either supervised visits with my client supervising, at least in public places. But if the court wants to allow him to have visits with his children, unsupervised, there needs to be restrictions and monitors to make sure that he is not drinking. Whether that's a breathalyzer on his only vehicle to make sure that it doesn't start, that he needs to breathe in there, blow in there every time to make sure that he is not drunk when he's operating that vehicle with the children there. He wants to kill himself on his own time, that's his business. But when he's driving the children, he needs to blow into that. When the children are with him, I think he needs a handheld breathalyzer as well, Judge, to make sure he is not drinking, because we certainly, given the testimony, the limited testimony today, we can't trust him. What we do know about addicts, Judge, is that they lie. It's a disease. And that's how we need to go forward with regard to this. My client wants an injunction that he cannot drink 12 hours before and at all during. It's a sad situation where my client has to educate her children to be able to identify what happens when their father drinks so that they can be diligent on their own. These children are 9 and 11, and my client has sheltered them to protect Mr. Salas. But now the children need protection from him, Judge, given what has happened on November 5th and the discovery that we just made today regarding October 1st. That is why we're asking for temporary orders in this situation to provide restrictions to Mr. Salas when he is with the children for the children's protection, well-being, and best interest.
Closing, Mr. Chu.
Judge, the injustice here is that Mr. Salas has been prevented from seeing his children after the signing of the court's order on December 5th. The injustice is the fact that they brought out this case to a fishing expedition and made egregious claims against my client. Not one point did they show that Ms. Garza had a material and substantial change in herself or her situation or her work or her living. That's the standard. It's not the standard that she feels that Mr. Salas is this. The court is not about feeling. This court is not about what ifs or what could be. Not one point in time did we hear anything about the children with Mr. Salas. His actions are his actions outside of that. Did we hear any testimony that the children were placed in danger? I asked those questions. October 1st, were the children with him? No. November 5th, did he have the children? No. Was he arrested? No. Is it illegal to consume alcohol? No. So they have not met their burden of proof as to any material substantial change as to Ms. Garza or as to the children. So as such, Judge, we ask the court to deny the temporary order request or deny the ex parte or lift the ex parte injunction so that we can continue with this case.
Just one point of clarification, and I guess it may or may not matter since it hasn't been raised, but just out of respect, I guess. Ms. Garcia, should the court refer to your client as Ms. Salas or Ms. Garza? I want to get that right. I don't know. All right.
I apologize if I referred to her myself.
Well, I mean, whatever the case is, I just want to make sure that I do it right. All right. Mr. Salas, Ms. Garza, in your case, cause number 2025 FLA 100C3, the court finds that it has continuing and exclusive jurisdiction over the matters in this case, that being jurisdiction over any changes or modifications to the possession orders and conservatorship orders over your two daughters, ages 9 and 11. What the court has heard today, and the court focuses on the testimony and the credibility of Officer Escobar and that of the purported victim, I guess, in the video. Ms. Salas, I guess, excuse me, I just said it myself. Ms. Garza is, I guess, has a stake in the matter, right? So, I mean, I heard both Mr. Salas and Ms. Garza's testimony, but obviously both of you and each are parties and have stake, so I give the appropriate weight to your testimony and your credibility, but I guess Officer Escobar clearly has no dog in the fight, for lack of a better description. In any event, the court takes it all together, the testimony of everybody present and that of the evidence presented and the exhibits introduced and offered and admitted. The court heard testimony and evidence about 2 instances that required police department intervention. And that's not to say that Mr. Salas is guilty or not guilty, because we're not doing that here. The court isn't exercising its criminal jurisdiction. So I'm not making a finding that you are guilty or not guilty of any crime. I don't do that here, but in exercising the court's civil and family law jurisdiction, I need to take these things into account, not to determine guilt or innocence, but to see what is in the best interest of your 2 daughters is. I think I had mentioned on the record in previous hearings that although the court didn't have any actual drug test, the inability or lack of a test is a legal positive. So that's already part of this court's record, and nobody objected to that at the time. And the court now knows that although it was court ordered to have a hair follicle test, that wasn't either done or it wasn't provided. One of the two, whatever the case is, it's just that portion of the court order hasn't been complete. So on top of the evidence, testimony, and exhibits, there is a legal positive on the record, and there's an incompliance with a hair follicle. On top of that, what the court recalls is that there was an in-person requirement in the underlying case, and yet after the court ordered a drug test, Mr. Salas did not appear in person, but appeared remote. And in fact, that same pattern was repeated here today. If the court order said be in person and you were, and then you come back in the afternoon and you're not in person, I'll let the conduct speak for itself. It's part of the court record. So the court at this time finds that there is sufficient information in the record to permit the court of finding that restrictions should be applied. The court hereby approves all the requests by Ms. Garza, except the breathalyzer for this reason. So the court is going to order supervised visits either at Safe Haven or at some mutually agreeable public restaurant.
Judge, if I may, there's a new facility that I've just encountered. It's called South Texas Visitation Center.
The court heard.
Yes.
And so it's a matter of what,
Just-
give me 1 second. What Ms. Garcia is referencing, I know I've never used this facility, but at the Board of Judges meeting at the last, I guess last Wednesday, the court heard, actually every single district and county court at law judge heard about this place. So Safe Haven or this other facility.
Safe Haven's not I don't mean to interrupt, but Safe Haven is not an option. I spoke with Ms. Everett last week. Their new federal funding requires there to be a finding of domestic violence in the court proceeding for them to be able to take on visitation. So Safe Haven in this case is not an option, Judge.
Court is going to order any viable public supervisory facility or mutually agreeable public restaurant. I'm not going to order the breathalyzer because that's I'll let you both finish texting. Just let me know when you're both are fully here and present.
That's not right.
You're communicating with the witness. So, supervised visitation at any viable public facility that allows for that between now and the next hearing, or any mutually agreeable public restaurant supervised by Ms. Garza or her designee. What I need you all to confer on, and you can mutually write it into the order, is that I understand the season that we're in. This court does believe that Mr. Salas should have a half-day visitation for Christmas. So figure out what place and what person can. If you agree to it, fine. If not, just leave it blank, and I guess I'll figure it out based on the evidence and testimony. The court finds that there is sufficient information in the record to permit this exercise of its discretion. Any and all requests are approved except the breathalyzer. There's going to be zero driving of these children. It'll be at a mutual place.
Clarification, Judge?
Not yet. The court hereby approves the attorney's fees that were testified to. The court finds that those are reasonable and necessary. $5,234.08 plus $1,500 for today. The court finds that that's reasonable and necessary. I am going to order one other thing, Ms. Garza and Mr. Salas. Don't talk about this case. And I heard that it has already happened. Just don't do it until further orders of the court. I'll hear from Mr. Chu now or in the future if he doesn't agree to now about his client's position as to the guardian ad litem. So just don't talk about this case. Don't talk about courts or hearings or anything. I debate whether to do the following, but I think in the interest of justice, I should. So in addition to being the sitting judge of this court, the court also, this is the only court that has a DWI specialty court. 1, 2, the court, this judge is also the chair of the judicial section of the state bar. That being the case, I think it is appropriate that the court say that any and all parties should refrain from ever invoking any member of the judiciary in any legal proceeding, and that includes police department investigations. I think that is sufficient cause for pause for the court. All right, these are the orders of the court, and the orders are due honor before.
Judge.
January the
Give me 1 second.
January the 26th at noon by submission.
I suggest it be as soon as next week. Actually, wait. December 22nd by 5 p.m. Ms. Garcia had a question and Mr. Chu had a question. Ms. Garcia.
With regard to supervised visits, who is allowed to supervise? Could it be my client, her parents? Who's allowed to be the supervisors?
The court said Ms. Garza or any of her designees, unless it's the facility, they can designate whatever professional they have on staff. Any other
And-
questions?
Yes, Judge.
Ms. Garcia, any other questions?
What's the length of time of those supervised visits? And how often?
If the court provides for any standard language, then go ahead and do that. But I would suspect. Let me hear from Mr. Chu.
That was my question, Judge. I mean, normally it's first, third, and fifth weekend, Saturday, Sunday, and, a couple hours. I mean, that's normally the practice.
First, third, and fifth weekends, but it's not the full weekend, obviously, because you're just at this place. I would presume 4 hours, first, third, and fifth Saturdays and Sundays. So ordered. Any other questions, Mr. Chu?
No further. Judge.
Ms. Garcia,
Attorney's fees, when are those due? When Mr. Salas pay those?
Mr. Chu, I can just, let me hear from you as to what amount of time you believe would be reasonable and necessary, or reasonable, not necessary.
I guess it should be 30 days after the signing of the temporary orders, Judge. That way it'll give us a chance to appeal it.
Let me ask you this, there was a request, and it's not set for today, but perhaps we can address this now. There was a request for a guardian ad litem. Any objection to that, or should I set that now for hearing in the future?
We objected today, Judge, and we can just have a hearing for it in the future.
Sure.
Judge,
Give
one
me
other
one
thing.
second. Let me set things up on the calendar. Court is gonna set that request for hearing January the 6th at 1:30. That's the guardian ad litem. And the court will hear anything else that you file between now and then on that day, January the 6th at 1:30. Any other questions, Mr. Chu?
No further questions, Judge.
Ms. Garcia?
Is the court going to put a restriction on Mr. Salas's consumption of alcohol during visits? Supervised or otherwise?
Any objection to that request?
Yes, Judge, we object.
Well, they're supervised. I just don't understand what any objection to the consuming of alcohol during visits would be.
Well, Judge,
Give me 1 second. The basis for the objection, based on the evidence, testimony, and anything the court has heard.
Well, there has been no evidence that he consumes alcohol during his visits with the children, so we object to any other restrictions that's being further placed on my client.
does he really need to
But that-
drink it during 4 hours?
I don't need to. Don't do that. I believe the court heard sufficient evidence to support the request. I was taking detailed notes at 7:22. There seems to be an assumption that the consuming of alcohol is necessary for the execution of business, and that's a good request in the best interest of the children, at least 12 hours before ending all visits. So ordered until further orders from the court. Anything else on this case, Mr. Chu?
Nothing further.
Ms. Garcia?
No, Judge.
Mr. Salas, Ms. Garza, I wish you both very well. I wish your two daughters all the best. I make these decisions in their best interest. I say this every now and then, and I guess sometimes it bears repeating. Please don't ever assume that the court likes any decision it makes. The only thing, and another thing, I think you may have heard it, because I know I said it to the other cases that were heard before you. I don't judge each of you or anybody, any person individually. That's not my job. I don't judge you morally or legally as the case is. What I do is I judge the facts and I apply the law and I give you the result. And that's just what's happened here. So don't assume anything else. Mr. Salas, Ms. Garza, I wish you both the best. Have a good holiday
And
season.
just one logistical question, for records, for purposes of appeal, how do we get a record of this recording today? And
Sure. You can find all information on our website.
Gotcha.
All right. Everyone have a good night.
Thank you, Your Honor. Thank you, Your Honor.
Everyone is excused.